Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3017, United States of America versus Johnnie Gamble, Appellant. Mr. Axum for the Appellant, Ms. Kalu for the Appellee.
Good morning, counsel.
Morning.
Mr. Axum, please proceed when you're ready.
May it please the court, counsel, Tony Axum on behalf of Appellant Johnnie Gamble. I'd like to reserve 2 minutes for rebuttal. Appellant Johnnie Gamble was seized when 6 armed officers in tactical gear came upon him quickly at night in a limited area of sidewalk and singled him out. Specifically, Officer Tejada singled him out. The specific moments of seizure were first, when Officer Tejada positioned himself to stop Mr. Gamble's movement away from the officers. Second, when Officer Tejada announced, just making sure there ain't no guns, that's it, and then asked Mr. Gamble if he had a gun. This accomplished 2 purposes. It accused Mr. Gamble of a crime and suggested that Mr. Gamble needed to remain in place to dispel the officer's accusations. And the third moment of seizure was when Mr. Gamble said that he did not have a gun, and Officer Tejada said, let me see your waist.
So you want us to hold that he was seized when Tejada walks up to him and singles him out before he even utters a word? That's a seizure?
In this case, there was a seizure at that point, and I won't say that in general, when an officer approaches someone and doesn't utter a word, there is a seizure. But in this case, Mr. Gamble was backing away with his hands up, and Officer Tejada came and stood in his path. So I would say to the court, yes, if an officer walks up to someone and stands in the path, their path of movement, that officer is conveying without words that I want you to stop. Mr. Gamble did stop.
What was Officer Tejada supposed to do that would have been compliant with the Fourth Amendment?
Well, this court has suggested that officers come up and if it's a consensual encounter, make it consensual. Come up and say, "Hi, we're out here. We're investigating this. Would you mind talking to us? You are free to go about your way if you do not want to talk to us." None of that occurred here. This was immediately like multiple officers descending at once in tactical gear at night. The atmospherics of the situation did not convey a consensual encounter. They conveyed the exact opposite, a coercive encounter that that everyone there should comply with.
Let's zero in on the moment that Officer Tejada says, "Let me see your waist." The government says that that's not a seizure at that point. What's your best case or cases that it was a seizure at that point?
Well, this court's case in the United States v. Wood, where an officer arrives at a location and sees someone walking away and says, "Stop, freeze," and the person stops and freezes and immediately drops the gun. The command itself was a show of authority, and when the person stopped, that was submission to the authority, and this court found that that was a seizure. There are other cases as well.
We've also said that the question, "Can I see your waistband?" does not demonstrate a seizure. And I think we said that in gross. And so if that, we can take that as a given, at least for now, that a request, "Can I see your waistband?" would not establish a seizure. And so I guess my question is, can the words, "Let me see your waistband," can they ever be a question? If they're framed, if they're said very politely, if just leave off the, "Can you let me see your waistband?" If it's just, "Let me see your waistband," can they be a question?
No, there's always an imbalance of power between officers in uniform, and certainly in this situation, but let's just say an officer in uniform, an officer.
But even if there's an imbalance,
words have meaning. I mean,
but even if there's an imbalance in power, it's true that notwithstanding that imbalance in power, the words, "Could I see your waistband?" are not indicative of a seizure.
a question this court has held is not indicative of a seizure. It is not necessarily a seizure. I don't think the court has gone so far as to say questions are never a seizure.
Right. It doesn't have to be a seizure.
But this is not a question. And
can it never be a question? Can words like
a command? I'd have to say a command by a police officer, given the imbalance in power, given it's logical that we want people to obey commands by police officers. And if a command is not a show of authority which somebody has to comply with.
So I think I might agree with you that if it's a command, then it shows a seizure. I guess my question is, there's a question, a request on one hand, and a command on the other hand. And words, it seems to me there are words that could be either. They could be a command, they could be a question. You just have to look and listen and figure out in context, was it framed as a question or was it framed as a command?
Well, I think the Supreme Court has said that the tone of the officers are the words chosen. And words chosen, again, have to have meaning.
Mm-hmm.
this was not something that began with, if the officer was, if this was a consensual encounter and my client was free to resist the command, then it's a very simple thing for the officer to say, may I see your waistband? That is not what occurred. It's a very simple thing. To add the could, can, again, the language has to have meaning, and a declarative statement or command is simply never a question.
Here's how the district court characterized it at JA 175. He says, and at that point, he specifically tells the defendant, and it wasn't a hostile tone of voice, but he clearly makes a demand, show me your waist. So what do we do with that?
Well,
You're not saying that any of that, but to the extent that's a factual finding, is clear error, right?
No, I don't.
And
I
I don't think the
take
government
issue.
argues that that's clear error either. Right?
I don't take issue with either the finding that it's a demand or that the tone is nice, but saying things nicely doesn't change that that you are requiring someone to do something.
Mr. Axum, if we assume that it was a demand and the first time the officer demanded that Gamble show his waistband was a show of authority, and then we assume that the seizure occurred when he actually raised his shirt and showed his waistband, it seems to me that there were three factual findings in the record that could amount to reasonable suspicion that would support that seizure. First, there's a finding that we're in a high crime area, quote, specifically related to gun possession, both violent and non-violent related gun matters. The first one. Second, the court found it was, quote, unusual when Gamble backed away with his hands up in response to the police arrival. And the court did say that that could be consistent with consciousness of guilt. I'm paraphrasing here, but said that that's subject to other interpretations as well. But third, and most importantly, the court said it was, quote unquote, suspicious when Gamble did not immediately comply with the directive, but instead pulled up his pants and, quote, was seeking to try and actually conceal his waistband, which occurred here. So those three findings of fact, which nobody is saying were clearly erroneous, why don't those add up to reasonable suspicion that would support a seizure when, at that point of seizure, when he raised his shirt?
Well, the first thing I'd say about the neighborhood and the high crime designation, that's just a contextual matter. And the court certainly had to look at the circumstances of this case, decide whether.
But the Supreme Court has held in Wardlow that that's a factor in finding reasonable suspicion.
It's certainly a
so
factor.
That's one factor, and then there's two more.
But the question is how do the facts of this case, how are they influenced by the high crime designation, we'll call it? Slowly backing away does not become a crime because you're in a high crime area.
It's not a crime, but the court found that it was unusual and is consistent with.
Well, that would place my mind in a double bind. If he has the right to walk away, it can't be that then walking away is a basis for reasonable suspicion. The Supreme Court has also said that defendants have the right to walk away when police arrive at a scene. They don't have to stay and talk or do anything. So for that to be a factor of I can't say that it's never a factor in the reasonable suspicion analysis, but it's not significant here. I'd say that it is entitled to very little, if any, weight under these circumstances.
I think in all of these Fourth Amendment analyses, there's behavior that could be innocent in some contexts, but could be construed as suspicious in others. I think that that's just a normal part of this analysis. And here the court said it could be construed in different ways. It could be construed as suspicious behavior, trying to suggest that he hadn't done anything when in fact he did. Because I think it's unusual just because the police arrive on the scene and somebody backs away from them, but not just backs away, like he doesn't want to have contact with them, but also is raising his hands in a manner that would suggest or could suggest that he was trying to conceal the fact that he was involved in criminal behavior, although it could be construed otherwise as well. So
But
that's a finding by the district court.
I fully appreciate that. There is no explanation. The government didn't elicit from Officer Tejada what crime backing away signifies. And really that gets to the heart of it, because backing away is an innocent act. So if it is suspicious, what is it suspicious of? General suspicion, general hunches are not sufficient for reasonable suspicion. General hunches don't allow the police, because something looks odd or something looks strange. There are many things that look odd and strange, and officers don't have the right to stop someone to investigate that further. What officers have to do is to articulate how that odd or strange behavior is criminal. And backing away on this, in this very case, no one has explained how backing away is criminal.
And so can you address the third factor, which was that he tried to actually conceal his waist?
The first thing that I would say about tried to conceal his waist is that's a very subjective finding. It's what the officer said. It seemed to him that maybe he was trying to conceal his waist. But one, there is no concealment. His waist was not concealed.
So you're saying the finding by the district court is clearly erroneous? Seems that you're conceding it was supported by the testimony of the officer.
The finding that the defendant was trying to do something?
He's trying to conceal his waist, is what the
Trying
district
to
court
conceal
said.
his waist is different from concealing his waist. I'm making a distinction between those two things. Concealing the waist is an objective fact that this court could review and determine, was his waist concealed? Did he do something to obstruct the officer from seeing his waist, as the officer, again, ordered him to lift his clothes and show his waist?
I'll give government counsel a preview of one of the questions I'll have for her, but isn't the more salient point that the demand was made before that happened? So how can that factor in as reasonable suspicion for let me see your waist when he doesn't do that until after that statement is made, that demand is made?
I would say yes. At that point, he's already been seized. The officer does not, or I should say, at that point, the officer did not have reasonable suspicion and had made a demand.
So what's the point of seizure?
The point of seizure is obviously when there's submission.
Which is when he lifted his shirt.
At the moment he begins to submit. And if you look at Government Exhibit 1, they refer to it as pulling up his pants, but it's an adjustment of his waist. And the officer gives an explanation for that. He says the pants are sagging. That is a logical, innocent explanation. He doesn't say because there's a crime.
But how is that a submission to the show of authority? If the show of authority was show me your waistband, and you're not showing the waistband, you're instead adjusting your pants, that's not the point of seizure.
I would take strong disagreement that you're not showing your waistband. It was all one movement. He lifted his pants.
It's the district court that held that he was concealing his waistband at that point. The point of seizure is when he lifts his shirt.
I have to
So
take
that if the
disagreement.
concealing happened before that, that goes to reasonable suspicion.
I have to take disagreement that the court found that he was concealing. There is no finding that something was concealed. Trying to conceal and conceal, there is a distinction there. Trying to conceal is an assessment of what the defendant is trying to do. And concealing is, from the officer's perspective, I could not see his waist. There is no testimony, there is no finding that there was any concealment in this case. So as the client, in fact, Mr. Gamble lifts his clothes above his belly button. The officer, again, gives an explanation for why he has adjusted his waist. And the explanation is because his pants are sagging, because he's not wearing a belt.
Can you address what the court should do if we find that the seizure does not occur until he lifts his shirt? Is there a case that says we assess reasonable articulable suspicion based on everything that happened before the submission to authority? Or do we assess reasonable articulable suspicion as to what the officer knew at the time he made the demand? Is there a case that answers that question?
I don't think there's a case that answers that question.
What about Hodari D? Hodari D is the case where the youth is running
Yes.
and there was no reasonable suspicion from before he was running, and then he throws an object and then he's seized. And the Supreme Court held that the throwing of the object counts in deciding whether there was reasonable suspicion because he didn't submit until they actually caught him. Isn't that exactly on point?
No, it's not exactly on point because Hodari D is a case of direct defiance of the officer's command. It is not doing something else in addition to complying with the officer's command. And here you have on the way,
Do you have any authority that distinguishes Hodari D from the situation? Is there a case about doing something?
No,
in
I'm
addition to submitting?
sorry, I don't have a case, but I think the facts of Hodari D make clear that there is a command, a show of authority, and then headlong flight away. Clear defiance, clear obstruction, clear non-compliance with the
The
command.
Supreme Court didn't phrase it that way. They just said the moment of seizure is when he submits to the show of authority.
That's correct.
That's the standard.
That's correct. So if it begins at the moment of submission, the second that Mr. Gamble brings his hands down to submit, to comply with what I'm not saying that under the formulation the court is suggesting any deviation, minor deviations from 100% compliance would be non-compliance, would be a lack of submission. And that's not what occurred here. It wasn't even 1 second of him adjusting his waist as he lifted his clothes. It was on the way to lifting his pants. I'd say it was all one movement. So submission is as he says in his mind, I am going to do what the officer says. I am pulling my hands down, and because my pants are hanging low, I adjust them and lift my clothes. So the submission begins as he brings his hands down. That's what I would say. If we're going to have to pinpoint that degree of precision, then there was submission before he adjusted his pants. Adjusting his pants did not interfere with the officer's observation in any way. The officer, even closer to the end of the hearing, didn't identify adjusting his pants as a basis for the stop at all. The officer said it was the backing away and the cell phone in his hand. I mean,
Make sure there's no additional questions for you at this time. Mr. Aston, we'll give you a little time for rebuttal. Hear from the government now. Ms. Kalu.
Good morning. May it please the court and counsel. Ching Namso Kalu on behalf of the United States. Your honors, we're asking the court here to affirm the district court's judgment in this case. The district court did not err in denying Mr. Gamble's motion to suppress because the evidence that came in during the hearing establishes that there was no seizure prior to the second time that Mr. Gamble.
So can I ask you about the first time though? So the first time is let me see your waistband. And that's the first one that the district court called a demand on page 175, as Judge Wilkins pointed out. But he clearly makes a demand. And then on page 180, he did make several demands of him to show his waistband. So if it's a demand is something that can't be said no to, that can't be declined. If it's a demand, how is it not a seizure?
Well, something that Your Honor brought up when Mr. Axon was arguing is that under this court's case law, similar questions can I see your waistband, have been held to not.
But that's a question. I mean, I guess to me, the thing is, and your brief uses the word request a few times. And I totally get that, because I'll tell you, if you watch the video and you listen to what's said, I think somebody could look at that and say the words are a question. Somebody could look at that and say the words are a demand. But it seems to me that a lot turns on whether one construes those words as a question on one hand or a demand on the other hand. And let's just play out the scenario where it's a demand as opposed to a question, because I'm viewing those to be different. If it's a demand, how can it be that there's not a seizure? Because the definition of a demand is that this is something that you have to comply with. And if it's something that you have to comply with, it seems to me you're necessarily seized.
I would disagree with that, Your Honor, because I think that Judge Pan raised this in some of her questions. There's no seizure until the suspect has submitted to the show of authority.
That, I have to say, if that's true, then that would mean that if an officer tells a subject, you need to show, and with no suspicion whatsoever, just walks up to a random person on the street and said, you're going to have to show me what's inside that bag. And suppose the person resists and says, I don't even know, I'd rather not. You're going to have to show me what's inside that bag. And then he opens the bag and there's something in there. It can't be that the submission didn't occur until he shows what's inside the bag, and therefore it's okay to demand that the contents of the bag be shown. That just turns the Fourth Amendment on its head, right? So it can't be that the submission happens at the time that you reveal the very thing that the officer demanded that you reveal.
I think that would certainly be, that's certainly not the fact that we have here. What we have here, as counsel conceded, was that Mr. Gamble started adjusting his pants. And contrary to what he said, there is testimony in the record from the officer that adjustment of the pants, this is at page 71 of the JA, that the officer understood that movement as an attempt to conceal something from him. And he did that before he complied with the command, which was, if we're going to call it a command, for the purposes of the question, to lift his waistband. And so I would argue that it's not until that point, when he actually does lift up his shirt, that he potentially has been seized. And I don't think that, I'm not arguing that it would never be, that some walking up to somebody and saying, let me see your waistband would never be, that would never result in a seizure. But rather, that's not what we have here for a number of different reasons. Some of them related to the officer's interaction with Mr. Gamble, and some of those reasons related to the circumstances surrounding.
Before you get to that, what do we do with the district court saying he clearly makes a demand, show me your waist? Isn't that a factual finding?
I think I would answer that two parts to that answer. The first, certainly the court was ruling from the bench, and the court was taking pains to distinguish this case from Mabry, where there were, this court, as I understand it, held in that case that it was the persistence of the questioning, not necessarily the question itself, that led to, or rather that transformed the consensual encounter into a seizure. And the second part of that, my answer to that question, Your Honor, is that it's not just the words that are used, but also the tone of voice. And another factual finding that Judge Walton made here was that the officer's tone of voice was not hostile.
But you're not answering my question. If the first part of the sentence, it wasn't a hostile tone of voice, is a factual finding, because you like that. Isn't the next part of the sentence where he says, but he clearly makes a demand, show me your waist, isn't that also a factual finding?
I think that was what I was attempting to say, yes, but that I think it's important to keep in mind that the court was.
So the district court made a factual finding that there was a demand to show me your waist.
I mean, that is what the district court said.
But you're not saying that that's clear error. I didn't see that in your brief.
We referred to the clear error standard.
Did you ever argue in your brief that the finding that show me your waist or lift up your shirt, let me see your waistband, that the finding that that was in fact a demand was clear error? Is that in your brief?
Oh, I see what you're saying. We did not argue that in the brief, Your Honor. But what I would say is that demands could be we would argue they should be understood on a spectrum. If a police officer walked up to somebody and said, in a hostile tone of voice, for example, get on the ground, or said to somebody in an urgent tone of voice, move out of the way. Those are different. There's different results from those.
I guess I don't know. I'm not following the spectrum once either of the endpoints is a demand, because even a polite demand, it could be the politest demand ever. It could be, listen, I hate to bother you. I'm so sorry. But I'm going to need you to show me your waistband. And suppose the person who's approached says, I'd actually rather not. Is that okay if I don't? No, look, I mean, this is a demand. It's a very polite demand, but it's a demand. You're going to need to show me your waistband. Isn't it? That's a seizure.
But I think with the facts that the court described in that hypothetical, there's repetition with the questioning, which is something that this court focused on in Mabry. And certainly the court can see in Government's Exhibit 1 that's in the record in this case, the nature of the officer.
So one demand isn't enough. It's got to be two. That's what we should write.
I think that is in large part what this court did write in Mabry. There's reference to the persistence of the questioning, and that is something that Judge.
But that's because persistence of questioning can turn the words into a demand. But if the words are a demand in the first place, I don't know how it can be that something's a demand and there's an option. The whole point of a demand is there's not an option. If there's not an option, then there's a seizure.
So assuming it is a demand and it is a seizure, was there reasonable articulable suspicion to support seizure?
We think that there was reasonable articulable suspicion to support the seizure because Mr. Gamble did not submit until. I'm trying to. We're talking with respect to the first.
The first. Let me see it.
Until he has submitted to the officer's show of authority, there was not a seizure. And the finding that the district court made was that, and because of that, I'll finish the answer, I'm sorry. Because of that, what the officer could see or knew at the time that it's in a high crime area. And I agree, walking away, not enough on its own for reasonable suspicion, but it is what the officer testified to, and I believe what the court found, that was enough in this situation to bring the officer's attention to Mr. Gamble because he was the only one that was backing away. So that just added to what was happening. And then trying to conceal, the act of trying to conceal something. So yes, Your Honor.
Why do we count even if we credit that it was an act of trying to conceal by adjusting his waist before he pulls up his shirt, why does that get to be added to the reasonable articulable suspicion calculus when the officer didn't know that because it hadn't happened yet when he made the demand?
And just because he had not submitted yet.
I find that notion pretty darn puzzling, I have to say, because then officer can come in full guns blazing, and it can be the most emphatic command ever. Suppose, show me what's in your bag. You got to show me what's in your bag right now. And then the person is nervous and tries to put the bag behind their back. So, boy, and then you say, well, you're trying to conceal the bag. That's reasonable suspicion. Now open the bag. It can't be that the fact that you create a reasonable suspicion by trying to conceal the bag in the face of a demand for which there was no reasonable articulable suspicion itself creates reasonable articulable suspicion to look inside the bag, can it?
It is I guess it's just the fact that, well, if we're assuming that it's a demand, you know, and that those are all of the factors, you know, that the high crime area, that the unusualness of him backing up with his arms up, the adjusting of the pants, you know, that's, the district court did not find that there was RAS until the second time that Mr. Gamble was asked.
Counsel, isn't the answer to Judge Srinivasan's question yes? I mean, the Supreme Court has held that the point of seizure is when there's a submission to a show of authority, and everything up until that point goes into the calculus for reasonable suspicion. That's the way the court has interpreted this, and isn't that what happened in Hodari D?
I would agree with Your Honor.
Really? So that the government's position, I want to make sure I understand this. The government's position is that an officer gets to come up to a subject and just bring down holy rain terror. And then the way the person reacts itself creates suspicion. That's just, what's the point of the Fourth Amendment? If you just get to walk up to somebody and impose what's everybody would agree is an emphatic demand, and then say, boy, if you're nervous, that creates suspicion. That's kind of extraordinary, isn't it?
I guess I would say what we are, the finding that we're defending here is Judge Walton's finding, but I agree with Judge Han that this case is similar to Hodari D. And Your Honor, if I may, I just wanted to respond, going back to your questions about Mabry. The questions that were asked Mabry were, let me see your sash, let me see your sash. There's the transcript of the questions laid out in the opinion. And so they are similar questions here. And so I think when I say persistence of questioning, those were also demands. And the body-worn camera is on file in that case. And it is, what happened in Mabry is quite different from this case. And I also would say—
In Mabry, the camera is—
The body-worn camera was submitted as part of the record in that case. If the court would like to compare, and we also would be happy to provide it if the court would be interested. But if the court is inclined to disagree with us, I hope that Your Honors will, if I may, I know I'm over time, to note that we would also argue that this case is distinguishable from Brody, which is, this is the third issue we brought up in our brief, and that so we're not asking, to be clear, that this court overrule. We understand that that is not something that this panel could do, but we do think that the decision incentivizes people to, in interactions with police, submit or maybe briefly submit and then run and throw away weapons or contraband in a dangerous manner. And it's clear on Government's Exhibit 1 that's in the record in this case that when Mr. Gamble fled with the loaded firearm with one round in the chamber, he threw it against an apartment wall. It audibly hits the wall. You can hear that on the body-worn camera. Thankfully, the gun didn't go off. However, it could have gone off. And this, in getting ready for argument, I did go back and look at some of the documents in the district court docket. Government admittedly did not raise this particular argument at the suppression hearing, but did in its sentencing memorandum refer to the dangerous.
So, counsel, I find this alternative argument quite extraordinary because a person running and throwing a gun is a very common factor that we see over and over again. And as a trial judge, I saw it over and over again. And the government is taking the position that every time that happens, any Fourth Amendment violation that took place before running and throwing a gun is purged?
I think that the position we're taking in this case is the way that Mr. Gamble fled in this case, throwing of a loaded firearm at a building so hard that—
So it has to be at a building.
I don't want to, I'm limiting it to the facts of this case because what we're arguing in this case, but I would say—
But the general principle is that you think the government is taking the position that if a suspect runs and throws a gun, anything that happened before that, any Fourth Amendment violation is purged.
I think it would depend, our positions, it would depend on the facts of the case. So if the manner of flight were shown to be dangerous. And that is something that this court did carve out in Brody, the manner of flight. Admittedly, generally, what the court was talking about leaving in a vehicle. But you could imagine a situation where somebody in running tosses a gun perhaps onto grass or into a bush. Maybe that in and of itself is not dangerous. But if you then add that someone does that near a school, for example.
But then you're asking us to adopt a standard that depends on where the gun lands?
Not where. I think it would still be a totality of the circumstances analysis. It's all part of the Fourth Amendment, totality of the circumstances. Whether the manner of flight was dangerous. Yes, manner of flight was dangerous.
Can I ask one question about I just want to make sure that you did argue in the brief that if the first "let me see your waistband," the second one was a little bit different, I guess, but the first statement that the district court deemed to be a demand, that even if that is a demand, there was still reasonable articulable suspicion by the time of the seizure.
Yeah.
You did argue that?
If there was.
In other words, I took.
Oh, I'm sorry. We argued that the district court didn't err in finding that the second time, fixing the point of seizure at the second request was that the court didn't err in doing that. So we did not make that argument in our.
As to the first one, as to the first of those two statements.
Correct.
With the second.
Focusing on what the court found.
Yeah, by the time of the second statement, I take it your point is that by the time of the second statement, there was reasonable articulable suspicion, and there might well have been.
Yes, and we would point the court, in addition to the facts that we've been discussing, to Judge Walton's factual finding at 175 and 181 in the JA, that in viewing the body-worn camera, something was visible when Mr. Gamble lifted his jacket.
And I guess what's come up in argument today is the possibility that there might have been reasonable articulable suspicion that arose between the time of the first, what the district court called a demand, and the time of what the second of what the district court called a demand. And there would be a question as to whether the seizure had occurred by then because there had been no submission ostensibly to the demand.
Yes.
But our review is de novo, correct? Our review of whether a seizure occurred is de novo.
Yes, yes. And if there are no further questions.
I think I want to just make sure that I understand your response to Chief Judge Srinivasan's question. Because I believe that Appellant pretty clearly makes an argument in his brief that the seizure occurred earlier than the second "let me see your waist" statement, demand, question, whatever you want to call it. Did you argue in your brief, even if you find that the seizure occurred earlier after the first "let me see your waist" statement, demand, question, that there was reasonable articulable suspicion at that point?
We did not argue that. We argued that the district court did not err in finding that seizure occurred at the second request. And we also went through each of the points of seizure that Mr. Gamble is, the fact that the officers arrived in cars and were wearing uniform. And we went through each of those claims and discussed why there was no seizure at those points. But yes, if the court has no further questions.
I do have one further question. Sorry, just to keep you up here for just a little bit longer. So the statement by the district court twice calling the first "let me see your waistband" a demand. Do you agree that that's a finding of fact?
I think that, those are the words the court used. I think that in view of the fact that the court was distinguishing this case from Mabry, and that the language that is used in Mabry was so similar in the sense that it was phrased as "let me see," that even if the court, this court, views that finding as the use of the word demand as a factual finding, that doesn't demand, no pun intended, that this court then say that there was a seizure when that first demand was made.
Okay, but you're not taking issue with the proposition that that was a finding of fact. In other words, I mean, I suppose one could try to argue that whether it's a demand or not is a conclusion. And we look at the historical facts on the ground to figure out whether it in fact constitutes a demand, the necessary upshot of which could be that there was a seizure at that.
It could be viewed as you know, to the extent that the court is, that the district court was characterizing that word is used to inform whether the district court was finding the police had made a show of authority, the conclusion that whether there was a show of authority necessary to trigger Fourth Amendment protections, then it could be viewed as a legal finding.
Okay.
So I think either way the court looks at it, that we would say that first demand was not a command that triggered the Fourth Amendment.
Yeah, I think the show of authority part would be a conclusion of law. The question of whether it's a demand or not could be a factual predicate to whether there was a show of authority. The district judge did call it a demand on more than one occasion.
Yes.
Okay, let me make sure my colleagues don't have additional questions. Thank you, counsel.
Thank you, Your Honor.
Mr. Axon will give you 2 minutes for rebuttal.
I'd first note that the government did not argue and the district court did not find that there was a seizure when Mr. Gamble first lifted his clothes. And we'd ask this court to find that in that regard, the government has not carried its burden to establish that there's reasonable articulable suspicion at the time of seizure, if the seizure is indeed earlier. But with regard to the demand and the tone, I think Mendenhall is instructive because it says the use of language or the tone of voice. Those two things are different, and the use of language is the demand. A demand or command or order is not converted into a question, which Mendenhall recognizes the tone of voice can be harsh or can be kind, but the tone of voice does not convert the words themselves into something different.
Can you address this issue of what do we do about pulling up the pants? Do we count it or not count it towards reasonable suspicion? And do you have any other authority on further reflection?
With regards to pulling up the pants, the first thing that I would say is that the Fourth Amendment, the difficulty with this is that for the government, I think, is that the Fourth Amendment allows people to keep things private that they want to keep private. And the waist area is private. So to Judge Srinivasan's point, if officers arrive at a location and demand to see something that is, by all accounts, private, and people, I understand young people walk around with their pants sagging, but
that's a show of authority, not a seizure, correct?
It is a show of authority, but the court is asking whether his reaction to the show of authority can be considered. A reaction that is defiance, a reaction that does not have an innocent explanation, a reaction that is obstructive might not be something that should be considered. That is not the reaction that we have in this case. In this case, we have a reaction that is momentary, brief, that is in the act of complying. Officer doesn't say, I couldn't see. He doesn't say, don't adjust your waist, don't do anything else. There were not very specific instructions that Mr. Gamble failed to obey. There's no testimony that he failed to do something.
So if he had been told, let me see your waist, and he kneeled down to tie his shoe, and in the course of doing that, the officer glimpses an ankle holster for a gun, that could be counted towards, and then he stands back up and lifts his shirt or his jacket. We'd count the viewing of the ankle holster there because he's not really, that's not part of the submission. That's the way we're supposed to slice the bologna.
I'm not sure that it can be sliced so fine even there, because again, there's not currently a standard for what constitutes non-compliance, I guess, if that were interpreted, if the officer said in those circumstances that was non-compliant to me, there was not some other innocent explanation for him tying his shoe, that might be the district court may be able to find that was non-compliance.
But didn't the officer testify here, and that was, I think, brought up in earlier questions, that he thought that the pulling up the pants was suspicious and appeared to be concealing because that was done before he showed his waist?
If we're going to be very precise and if we have to home in on exactly what the officer believed and what the officer could and couldn't see, I think we also have to be very precise on what the officer said. And the officer did not say that it was non-compliant. He said it seemed strange. That is it. He did not say it was suspicious. He didn't provide, and I don't want to turn too much attention, but pulling up the pants is not something that is inherently suspicious. It's not suspicious in a high crime area. It is not criminal. So
isn't there a factual finding? There was a factual finding that it was suspicious and that he was concealing his waistband.
But in order to make that factual finding, or I think, I'm not sure that that's a factual finding so much as a legal conclusion, that it amounts to reasonable suspicion. In order to make that legal conclusion, you have to have objective facts. What are the objective facts? It was adjusting the pants was criminal because what? Because there's not a single fact in this record that I identify how adjusting the pants is criminal. We're talking about concealment, and then we're right back to this problem with the Fourth Amendment that allows people to conceal. The Fourth Amendment allows people to keep things private that they want to keep private. So that he adjusted his pants on the way. I mean, this isn't a case of like open defiance, flagrant defiance. It's not a case of Hodari D where the officer says, stop, come here, and the person turns and runs in the opposite direction. This is all within the course, in the course of complying with the officer's command. So there may be cases where there is testimony that adjusting the waist was suspicious because there was something holding the pants down, because in the officer's experience, every time that happens, I find contraband. There is no testimony, there is no evidence of that here. In fact, in this case, the officer says, I hate beating a dead horse, but he provides the explanation that his pants were sagging, so he pulled them up. He provides the innocent explanation himself. Concealment doesn't mean anything.
I mean, you could conceal to say no. The subject could say, you know what I'm doing? I'm concealing my waistband. And you know why I'm concealing my waistband? Because I don't want to show you my waistband. That's the client is in when the officer makes a demand without reasonable suspicion. And I think it's incumbent on the government to establish reasonable suspicion before that point. And to the extent that there's a question about that, the government didn't carry its burden. There's not additional questions? Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Number 22-1300, Window Covering Manufacturers Association petitioner versus Consumer Product Safety Commission. Ms. Zaharsky for the petitioner, Mr. Myers for the respondent.
Good morning, counsel. Ms. Zaharsky, please proceed when you're ready.
Good morning. My name is Nicole Saharsky, representing WCMA. With the court's indulgence, I'd just like to take a minute to frame the discussion about what this rule does. There are three types of corded operating systems that are used for window covering. First is the traditional cord lock system, where there's a free hanging cord and you pull it to make the covering go up and down. The second is the retractable lift system, where there's a wand and you pull the wand to make the product go up and down. There is a cord attached to the wand, but it's like up at the top of the window covering. It retracts into the top rail when not in use. And then the third is called the continuous loop system. That's where there's a cord or a beaded chain that's in a loop. It's attached to the wall. It's kept under tension. You use it like a pulley system to make the product go up and down. And none of those are used anymore for stock products as of 2018.
Can I just ask a question? Does the rule also cover the device that is used if it's a shade blinds to open or close the blinds?
No,
which is sometimes a twist wand, sometimes two cords.
Those are tilt cords or tilt wands. Those aren't covered.
That's not covered by the rule.
Covered by the rule. They're not at issue here. There are also inner cords in some of the products. Those aren't covered either. It's only what are called operating cords that make the product basically go up and down or from side to side.
Thank you.
Okay. So these operating cords were eliminated from stock products in 2018, but the industry needed some time to deal with that for custom products because sometimes you need cords in custom products. We're talking about windows that are sometimes bigger than 10 feet tall. And so it's just difficult with a cordless solution to get the product up and down. And so the rule at issue here is regulating custom products. And we think it has pretty significant problems, both in terms of the substance and the effective date. And in terms of the substance, what the statute requires the agency to do is to figure out the degree of risk that remains in light of the measures the industry has taken. And if we go back to those three types of window coverings, we have first the traditional free hanging cord system. Well, those are not allowed, even for custom products, as of the 2022 industry standard. So those are off the table. Then you have the second type, which is the retractable, where you pull the wand. There have never been any safety incidents on those. The government doesn't cite any. They've been used for 25 years, no safety incidents. And that's not super surprising because the cord is way at the top of the product there, and it retracts when it's not in use. So that leaves us with this third type of system, which is the pulley system with the continuous loop. And there, the government and the industry have a disagreement about how those products should be addressed. But what the government had to do here was to look at really this like small subset of products at issue and say, there's an unreasonable risk remaining. Here's what the degree of risk is, and here's a cost-benefit analysis. And there's a lot of problems, we think, with the way they handled that, but the two main problems are that they rely on data and incidents that are just decades old. They just don't account for any of these new safety measures. And then there are some parts of products like the retractable or the commercial segment where there are no safety incidents whatsoever. The government did not find any, and it didn't even consider cost for the commercial products. And I just want to say one, I'm sure the court will have questions, but just one note about the effective date, because this is really an independent problem. the commissioners decided to override the staff's recommendation here and put in place a 6-month effective date. And that's why we came to this court and sought a stay, because it was going to cause just hundreds of millions of dollars of disruption to this industry, which is 97% small businesses. The staff said, based on hundreds of comments, that the staff found credible that the industry can't create new compliant products in the 6 months. They said it can't be done. We've looked at our own knowledge of supply chain. We think these comments are credible. They got comments from the Small Business Administration. They said it can't be done. And the commissioners overrode that, and with no independent risk or feasibility analysis. And really the problem here is that this is a pretty unique statute. It puts unique burdens on the agency in terms of the kind of findings they have to make, including substantial evidence to support that effective date.
So the government on the
Go ahead.
on the effective date one, I just have a question about the effective date. On the effective date point, the government makes the argument that under the way you're looking at the two provisions that both reference effective date, that you're rendering the good cause one superfluous or nugatory, because it does establish a default that says that as long as you're within 180 days, it's okay. You go outside 180 days, the commission has to show good cause. What's your response to that?
Actually, we think it's the government's view that would cause one of them to become superfluous, but let me explain why. There are these two independent provisions. They were put in the statute at the same time. They have to be read together, right? The one that the government relies on says that there's a 180-day effective date unless there's good cause. And then there's a separate requirement that says that the agency has to justify, including the effective date, justify that the effective date is reasonably necessary using substantial evidence. And so what that means is, that there is a 180-day effective date, but if it's not reasonably default effective date, but if it's not, reasonably necessary based on the substantial evidence in the record, that effective date isn't allowed under that separate provision of the statute. And so that's the provision in section.
But isn't the best way to read those two together that you don't pick something shorter than 180 days unless you have, some good cause, but that the default is 180 days and you only have to have good cause to delay it further? Why isn't that?
Well, the staff here found that there was good cause to go beyond the 180 days.
That's a different argument as to whether they had good cause or there's substantial evidence in the record to support disagreeing with the staff. But you seem to be making a different argument also, which is that they had to make a finding that 180 days was appropriate, and they didn't make that finding. Aren't you making that argument?
Yes, that is exactly the argument we're making, that there are both of those provisions and that the court's job is to give effect to both of those provisions, right? And so the first provision that the government relies on says 180-day effective date, but that's not an upper limit if it's something other than 180 days is allowed for good cause. And there was a good cause finding here. But there is this separate requirement that we think the government is really overlooking. And it's really an important requirement. Just to kind of frame this, the most important things that the agency has to do here are all in the findings that are required in section 2058. There's the provisions F1 and F3, and it says the government has to make these specific findings. They actually have to be part of the rule itself, not just evidence to support the rule, but they have to be in the rule itself. And then the judicial review provision says that all of them have to be supported by substantial evidence. And so one of the findings that has to be made is the rule, I'm reading from 2058 F3A, the rule, including its effective date, is reasonably necessary to eliminate or reduce an unreasonable risk of injury associated with such product. And then the judicial review provision says that those particular findings have to be supported by substantial.
So is there any situation in which the commission would make the reasonable necessity, whatever the exact words is right there, and as to the effective date, and the effective date, let's say, is a year, so it's beyond 180 days, then does that necessarily establish good cause?
I don't know that there are any cases addressing those provisions. I think it probably would establish good cause because the cause would be that it's necessary to serve to address the risk that is supposed to be addressed. So I think the point is that these are the default provision is just a default, and we think the government is giving very short shrift to this separate provision, which is, that these very particular findings have to be made to justify the rule. And I just think it's notable that, this effective date provision, it's in here as part of the findings that Congress said the rule, including its effective date, has to be reasonably necessary. And when you're talking about pretty significant consumer products that take, a while to get the supplies, to design them, to manufacture, it's like not surprising that there would be effective dates of longer.
Can I ask one question about the implications of the effective date argument? So let's suppose, just for argument's purposes, the government resist this, but arguendo, if we ruled in your favor on the effective date and vacated the rule because of the effective date, then what happens to your constitutional challenge about the removal authority?
Well, I mean, first of all, if you think there's a problem with the effective date, we think the entire rule should be vacated because the judicial review provision says that the rule shall not be affirmed unless all of the findings are supported by substantial evidence. So we think the entire rule should be vacated and sent back. And in those circumstances, the court would not need to address any constitutional argument because the rule would be vacated. I mean, we've obviously—
Can we not vacate? In a lot of situations when we have a circumstance like this, if there's one particular part of the rule that's problematic, we'll try to do what's effectively a severability analysis to figure out whether the remainder of the rule stays intact, given the problems with the one. The effective date provision, you started out by saying it's an independent argument. And
yeah.
So if the effective date part of the rule is problematic, then could we not vacate the rule as to the effective date?
Well, as you indicated, the court certainly has decisions that talk about partial vacature and when that might be appropriate. We think that the language of the judicial review provision here suggests perhaps that this is not an area where there should be partial vacature because it uses language that's pretty unique in the U.S. Code, that the consumer product safety rule shall not be affirmed unless the commission's findings under sections 2058 F1 and F3 of this title are supported by substantial evidence in the record taken as a whole. The way we read that in light of all of the very specific findings that are required is that the entire rule should be vacated. I, of course, understand that the court has cases addressing other statutes where there's consideration of partial vacature. But, to be fair, we don't think, or to kind of address another issue, we don't think that partial vacature would make sense for, independent reasons, which is the analysis that the court failed to do with respect to the risk and with the cost benefit analysis. And we're not coming to this court and second guessing, judgment calls that the agency made. We're talking about data that is either fundamentally skewed or just missing. I mean, missing analysis. And what I mean by skewed is the use of incident data that goes back to 2002 and just doesn't account for the safety improvements that have occurred over decades, where this industry has been working so hard to make those safety improvements over decades.
Maybe you answered the question, but let me just ask the Chief Judge's question a little differently. So assume for the sake of argument that we agree that either on the effective date or one of the other arguments that you prevail, and assume that we agree with you that that means that we vacate the entire rule. Should we, though, address all of your arguments so that when the commission redoes the rule, if we were to do all of that, they'll know, oh, their cost benefit analysis was, we thought that was either fine or not, or all of the other ones. Does it make sense for us to address all of those arguments so that the commission knows what we think of them, or you think that once we find one, we just vacate the whole thing and send it back, and it's akin to an advisory opinion or something for us to opine on any of the others?
Well, I mean, of course, it's up to the court in terms of how it wants to proceed, but the court does have all of the arguments before it in terms of the various problems with the rule, including the constitutional problems. And so with respect to the problems under the Administrative Procedure Act and the Special Consumer Product Safety Act, we think that the court should go through and address those. We think that those problems are pretty obvious and actually very similar to many of the problems that caused the 10th Circuit to invalidate the rule in Zen Magnets. I think Chief Judge Srinivasan's question was looking more towards the constitutional issue if the rule were vacated. That, I think, might be a tougher call for the court. Of course, it's up to the court, but normally the court tries to avoid constitutional questions if it can. Although, of course, if the court saw a problem with the structure of the agency here, it would the solution would be to make those folks removable at will going forward, and then send the rule back or vacate and send it back for them to consider it again. So
if we found a problem with the effective date and remanded to address that, that wouldn't reopen all the other issues, such as the cost benefit analysis, and you didn't give us the data for this. That would not be touched, correct? And then you would just appeal again those issues after the effective date is addressed?
I mean, I think it's up to the court in terms of partial vacature, in terms of what kind of guidance it would want to give. I mean, we would urge the court to address those issues now because we think those failures are pretty glaring. And I should say, you know, the industry here has been wanting to work and has been working in partnership with the agency for decades. And so getting the agency to look not only at the effective date, but at some of the other real failures with the rule, we think is very important. And let me just give one example, which is the incident data on which the agency relies. You know, this is something where there was a real failure of the administrative process and where, you know, the industry wanted it to be more of a notice and comment and a collaborative process, because the agency said, you know, we've got some incident reports dating back to 2009 that we think show an unreasonable risk associated with corded products. And our response to that is, okay, like, tell us what those are, because a lot of the corded products have been eliminated. The ones that everyone was most concerned about with the free hanging cords have now been eliminated for all products as of 2022. And so we want to know, of these incidents, are they products that complied with the new standards, or are they older products? You know, we want to know if there's still risk there. And the agency would not provide the reports at all during rulemaking. It was not until well after rulemaking, when we were 5 days before submitting our brief, when we said, like, look, you told us these are part of the administrative record, and we see these reports, and they provided a spreadsheet. It's very small and hard to read, and also doesn't really provide the data to know whether these are newer products or older products, and whether the risk.
I mean, you started out by saying that some of the incidents that are the predicate for the rule are outdated, but I guess you don't know that, right? I mean, that's the point of not having the underlying incident stuff, is that you don't necessarily know, because you don't necessarily know what kind of mechanism was used in the circumstances underlying the incidents that gave rise to the rule. And so it may be a problem that you don't have the incident reports, the underlying information, but you can't necessarily say whether they're outdated or not.
Well, we do have some information. So let me tell you what information we do have and what we don't have, and what we can tell from the information that we do have. We have that there were 209 incident reports. They indicated whether they were stock or custom products or unknown. This rule that we're talking about only regulates custom products. So of course we wanted to know how many are custom products. They identified only 36 of those that are custom products. And then actually 3 of them didn't involve operating cords. They involved—
Well, not 36 of the 209, but because it was 36 of— there was 36 that were definitively custom, but that doesn't mean that it's only 36 of the 209 that were custom, because there were several for which it was unclear whether it was custom or stock.
There's some provision that there's some amount that's unknown, actually like 60% they said were unknown. And they did indicate what, to the extent that they knew, what type of cords were involved. And so for some of them, they did indicate on this spreadsheet that they provided well after the rulemaking process that they were the traditional free hanging cords. So we know that those are ones that have been eliminated. And then actually in the rule, the agency acknowledged that they think that half of the 33 custom incidents would no longer occur under the new voluntary standards. We don't know exactly how they know that, because they have more information about the products than we do. So the point is, we do know something about these 209 incident reports, which tells us that it's really not 209 that involve customs, that it also involves a lot of stock products, that some of them involve the free hanging cords that don't exist anymore, and that the agency itself tells us that of the ones they know are custom, they think at least half would be eliminated by the new voluntary standard measures. And our response to that is, great, then let's focus on what remains, but they're not focusing on what remains. In their cost benefit analysis, for example, when they're figuring out the benefits of the rule, they're using old numbers from 2002, and they're using numbers that don't account for even their own acknowledgement that the voluntary standard would decrease the risk and eliminate about half the products. So I know that this gets awfully technical, but this is an area in which I think Congress wanted that kind of technical analysis to happen, because it put these very specific findings in the rule. And I think it comes from a recognition that the agency has power to regulate here, certainly, but that it has to really determine the degree of risk that remains in light of the voluntary standards, and then also to determine what the costs are and whether the costs outweigh the benefits.
So I have one technical question about the cost benefits. So on the cost part, the argument that you started with in both your opening brief and your reply brief has to do with a baseline against which the cost factor is applied. And your point is that, well, the baseline was off because it's either exclusively or at least largely made up of stock products as opposed to custom products. Did you submit information, or do we have a sense of what the delta would be? What's the difference between if you start with the baseline custom or start with the baseline stock?
I think that there are comments talking about that custom products are more expensive. I think that the agency.
Like how much more? I guess that's the question, because if it's not that much more, then the cost benefit analysis already is, and it's inevitable in this situation. It's going to be, there's going to be a big range, and it's going to be based on things that are very, very hard to value, a child's life. I mean, this is, so I guess the question I'm asking is, what leads us to think that it would actually be meaningful?
Well, I mean, we're talking about products. I don't have an exact number for you in terms of the delta, and respectfully, we don't think that that's like our burden here, because the CPSC is the one who has to do the cost benefit analysis. I also would mention just off the top that there's some costs that aren't accounted for at all, like the whole commercial side of the market, which is like 25%. This cost not accounted for. But let's take that off the table and let me directly answer your question. So there's been an acknowledgement, I think, during this whole voluntary standard process, actually going back to 2018 and 2019, when the industry said, we're going to address stock products first. They're 80% of the market. They're smaller. They're simpler. They're easier for us to come up with cordless solutions, like the ones that have a spring where you can just push it, up and down from the bottom. And everyone at that recognized at that point that custom solutions were going to be more difficult because of the bigger products. They're bigger, they're heavier, they have to use different materials as a result. So there is a significant delta there. I don't have an exact number for you on the significant delta, but even the CPSC recognizes that cords have to be used in some custom products because some of the products are like literally over 10 feet tall. For example, when the staff recommended their effective date, they picked a 1-year effective date for under 10 feet tall and another one, a 2-year effective date for over 10 feet tall. It's because these are huge products that cost like thousands of dollars. They're like nothing like what we might buy at Home Depot for our homes. And so that's that. I think from the cost perspective, just to kind of summarize from the cost perspective, failure to consider whole categories of costs like the commercial analysis and then also the reliance on stock products from the benefits perspective. We think that they've relied on kind of this idea of 20 years ago incidents that's not borne out by the more recent data. And I guess I know I'm over my time, but if I can just make one other point with the court's indulgence, we really do think that this is like the Zen magnets case that was faced in the 10th Circuit, where they invalidated a rule about magnets. It actually has some of the same problems in terms of not recognizing and accounting for a trend in the data, relying on incident reports that weren't clearly about the products at issue, and then had the same problem of not accounting for a category of costs, where there was the cost that the rule would impose on the scientific and educational community. And I guess just the last thing I would say is, I understand that these are important products, and we've worked very hard over decades to make them safer and safer, but Congress put in demanding requirements here. And when it has wanted to give the agency more discretion, it's done so. This court had a case, about 8 months ago called FinBin. It involved infant products. And in that case, the court recognized that the CPSC requirements are demanding, that there's a demanding cost benefit analysis, and that when Congress wants to give the agency more leeway, it does, specifically in different provisions like the ones that applied to infant products. So we just think that, what the agency did here didn't come close to meeting its burdens under the
So let's suppose we don't find merit in any of those arguments, and we feel like we have to reach then your constitutional structural argument. Why isn't this case controlled by Collins v. Yellen in that there's no compensable harm here? And so we don't even really have to reach the merits of whether the for-cause provision violates the Constitution.
So we think that Collins is pretty distinguishable because the court there limited its decision to retrospective relief, and we're seeking prospective relief. There is a rule that is causing harm, hundreds of millions of dollars to the industry if the effective date goes into effect, and if the rule goes into effect in 6 months. So that is prospective ongoing harm as a result of the rule. Collins addressed a very different and frankly kind of weird situation. Collins was limited to retrospective relief because there were shareholders in Fannie Mae and Freddie Mac who were seeking to invalidate the Third Amendment, this dividend formula that was used in a contract, but actually that had been superseded by another contract. And so there wasn't, an ongoing problem that the shareholders were arguing about. They just wanted to invalidate this dividend formula and get money back going backwards. And then the situation was a little more complicated than that because there were two directors of the FHFA involved. There was an acting director who chose to put that third amendment in place in the first place, who adopted the contract. And then there was another director that implemented that contract. And so the first acting director was removable at will, so there wasn't a constitutional problem. But then the second director had a constitutional problem that the court identified under SELA law because it had been the one implementing this. And so the Supreme Court, I think, was understandably in kind of a weird position there, that there was kind of like a half constitutional problem and half not constitutional problem, and only a claim for backward-looking relief and not prospective relief.
I'm not sure that the principle in Collins, it's true that it involved backward-looking relief, but I don't know that the principle there is limited to backward-looking relief. And there's other courts of appeals that have applied Collins in the same context as this case, right?
Right. So we think that the relevant rule comes actually from the court's decision in Free Enterprise Fund versus PCAOB. That was prospective relief sought. That was a case involving inferior officers, but the court found that there was a problem with removal restrictions. And the court said we have to provide declaratory relief going forward to make sure that going forward that the rules are applied in a constitutional manner. And so we think that is the relevant decision. Now, you're right that there are cases. There was a decision from the Fifth Circuit, the Second Circuit, and the Sixth Circuit that have applied Collins to the situation of prospective relief. Respectfully, we think that they're wrong. Now, the Fifth Circuit case has gone to the Supreme Court now on a different issue about the funding of the CFPB. The second one is very recent. We don't know what's going to happen with that. The Sixth Circuit one is actually up on petition for cert at the Supreme Court right now, although it has two issues and the government confessed error on the other issue. So whether the Supreme Court ever reaches the remedy issue is a question mark. I guess the point is, this court isn't bound by any of those other court decisions. It's bound by the decisions of the Supreme Court. And the Supreme Court, I think, has told us two things that are pretty relevant here. The first is under the SELA law decision that there is absolutely a constitutional violation here. The Supreme Court said that the general rule for principal executive officers is that they have to be removable at will. It said that the court has said it's recognized two exceptions to that are the outermost limits of the constitutional authority. The government relies on one of them here that involves multi-member expert agencies, but the Supreme Court didn't say the exception was for any multi-member expert agency. It said only those that don't exercise substantial executive authority. So we think that under SELA law, the constitutional violation is clear. Then the question is what the remedy is, and we need to look to what the most relevant Supreme Court decision is on that point. Whatever you think of the reasoning in Collins, the Supreme Court was absolutely clear that it did not involve prospective relief. It only involved the situation of retrospective relief. And the case that the Supreme Court has had that's about prospective relief in this context is the PCAOB case, Free Enterprise Fund, and that one provides a remedy here. And I guess I don't.
How do we know what the court meant by substantial executive authority?
Well,
and how does that map onto this commission?
I think the court has given examples in the Collins case that rulemaking authority is substantial executive authority. In Kaiser, I think the Kaiser versus Wilkie, which is from a few years back, the court said that adjudicatory authority is substantial executive authority. In SELA law, the court looked at the ability of the agency there to bring actions, civil actions in court and seek penalties as substantial executive authority. And here the CFPB has all those things and more. It can issue recalls. It can affect over $1 trillion of the U.S. economy. And I don't think the government is making any argument that they don't have substantial executive authity.
So do you think that in effect, Humphrey's executor has been overruled?
No, the Supreme Court has said very carefully, very, very carefully that it's not overruled. And the reason that they said that it is within the exception that the court identified is because there the Supreme Court believed that the 1935 FTC was not exercising substantial executive authority. That's what the court said in its 1935 opinion. It described the authority as quasi-judicial and quasi-legislative. And then the Supreme Court in SELA law, I think, had a very telling, I think it's footnote 4, a very telling footnote. It said, look, we're taking Humphrey's executor on its own terms, the way that the court described the 1935 FTC's power. We're not going to look behind it to see if there were latent powers that the Supreme Court should have recognized and didn't rely on. We're going to take Humphrey's executor as it stands. And so in that case, which the Supreme Court has characterized in SELA law as not exercising any significant executive authority, that's just very different from the case here where I think the agency is admitting that there's an exercise of very significant executive authority. And I guess if it's all right, I might just say one quick point on the remedy question, which is, I think it would be extraordinary to say that there's an ongoing constitutional violation and really, no prospect of a remedy available. The idea that we would need to show make some kind of showing to actually get a remedy here. I mean, we're talking about a rule that is in place. It's affecting an entire industry. It's, we showed at the stage that we're talking from the effective date of, millions of dollars, hundreds of millions of dollars of hurt to this industry. We also know that it's 97% small businesses. The Small Business Administration came to the agency here and said, don't do this 6-month effective date, you're going to hurt people. And so the idea that there's this here and now injury, as the Supreme Court has called it, that doesn't have a remedy, we think would be really pretty extraordinary.
My colleagues don't have additional questions for you, Ms. Harthy.
I actually have a question. I'd like to go back for a moment to the incident data, because assuming that is problematic, that they didn't disclose that to you earlier. I understand that our case law requires you to show that you were prejudiced by that. And I didn't see you arguing that, the prejudice point in your opening brief. I'm kind of wondering if that's forfeited, the prejudice arguments, and also how actually were you prejudiced? Maybe that's kind of implied by the problems you've had with it, but I haven't heard exactly how you were prejudiced. What would you have done if you had had that?
I think we would have had an opportunity to provide comment and to address the risks under the rule during the notice and comment process. So I think that because this is, the risk analysis has to be part of the findings under the rule, under the CPSA, that this is the agency's burden with respect to notice and comment, that it has to provide notice of what's, the basis for those findings and give us a chance to comment on it. And so I don't think that there is a prejudice requirement there, but I think the prejudice is actually pretty obvious in terms of that there was absolutely no ability for the public, for the industry to comment on this during the notice and comment process. And this is just not like some small part of the rule. This is like their whole justification for the rule is we see a safety risk here. And what they're relying on is, we're concerned about free hanging cords. Well, those were eliminated in the 2018 and 2022 voluntary standard. So, the industry is very interested to know what else the agency is concerned about, because after all, it's been the industry that's been addressing these things for decades and decades. So the idea that there was just absolutely no opportunity to comment during the rulemaking process and that it resulted in a rule that is, requiring the industry to develop completely new products. We haven't really had a chance to talk about this, but what the industry requires for both the retractable systems and the loop systems are products that don't exist now. They are products that you have to come up with from scratch, which is why when the staff did its effective date analysis, it said, okay, the commenter said they need time to get the materials, they need time to do the design, they need time to do the manufacturing, and then they have to get these products to consumers. They tell us that that's going to take 2 years. We think that that's credible. It's consistent with our own view of the supply chain. It's what the SBA is saying, et cetera. And so I think the prejudice is clear, both in terms of just the complete sandbagging during the administrative process. And I don't say that lightly, but I think that's what occurred here. And then the result of that sandbagging, which is now we're subject to a rule that we can't comply with in 6 months and that we just don't think is even close to justified.
At the time of the rulemaking, were the voluntary standards for custom lines in place?
So the 2018 standard had made some changes for custom products, including defaulting to cordless products, limiting the length of cords in products, some requirements for tension devices in the loop products. So there were several custom requirements put in place in 2018. Those were in effect. The 2022 voluntary standard was not yet in effect, but the revision to the standard for 2022 started in 2019, and the agency was involved every step of the way. We officially opened a process under ANSI.
But under the statute, doesn't the statute say that the agency has to consider voluntary standards that are in place, right? Isn't that the way that the statute is written?
There's a whole bunch of requirements in the statute. We're not relying on that one with respect to the 2022 voluntary standard. We're relying on a different provision that says that the agency has to find that the rule imposes the least burdensome requirement that prevents or adequately reduces the risk. And here the agency actually recognized that the 2022 voluntary standard, which it had been involved in coming up with in partnership with the industry, it recognized that that was a potential less burdensome alternative. It actually considered that as a less burdensome alternative. You can look at that in the final rule in JA 22. So it recognized an obligation to consider it. It wasn't under the provision that Your Honor was citing, but it was under this different provision. It's F2058 F3. And, there we just think there was, no real consideration of the risk that remained under the 2022 voluntary.
And can I come back to the effective date for a moment? Because the commission balanced the risk of severe harm and death to young children over the entire service life of non-compliant window coverings against the possibility that some styles of custom window coverings may be less available during a transition period. That's how they justify the effective date. And your position is that's not justified by substantial evidence. And it seems to me what they're saying is that during this period before we, I guess after the effective date, but before the industry is ready, I guess, to change their offerings, there's going to be these non-compliant window coverings being produced. And these non-compliant window coverings are dangerous because once you install them, they're there for decades, potentially. And so that presents a risk of harm to children. And they're balancing that against, and during this transition period, you're just saying you're not ready, we're not going to have these available, they're not going to, because, it's burdensome to you. And they're saying, well, it's more important to us that we protect the children than make sure that we have all these window coverings ready on day one. And so I guess I'd like to understand in more detail why you think that's not supported by the evidence.
Right. I mean, that's the problem, is that it's, conclusory statements that aren't supported by the evidence. And let me start with the risk to children, because that is absolutely our number one concern here, something the industry's been working on for decades. So the staff actually did its own analysis and said that any benefit from a 6-month rule, as opposed to a 2-year rule, that any safety benefit would be very small. That was the staff's analysis after looking through all the comments. This is the staff that even relied on those 209 incident reports that we think don't even make sense here. That even in light of that, the staff said that any safety benefit would be very small between 6 months and 2 years. And then the staff balanced that. The other side was against the costs of compliance. There were conclusory statements that the commissioners made that they think that the costs of compliance are overblown, but there wasn't evidence to support that. Only the staff went through the evidence and found, these hundreds and hundreds of comments that the statements were credible, and that it was going to be very disruptive to the industry, that there was going to be a significant impact on small businesses. And, I'd urge the court to take a look at that analysis. That's in JA 428, 495, a couple other places, because the staff looked at evidence and relied on the evidence, and the commissioners didn't. It's just they made some conclusory statements. You identified one of them, but they're just not supported by the evidence. And here, this is a statute that says that the effective date is one of the findings that has to be supported by the evidence, and we just don't think it is here. The staff said these are credible comments, and the commissioners never came back with any reason to say that they weren't credible.
There's no additional questions. Thank you, counsel. We'll give you some time for rebuttal. We'll hear from the government now. Mr. Myers.
Good morning, Your Honors. May it please the court. I'm Stephen Myers on behalf of the Consumer Product Safety Commission. I think it's important to understand that the safety standard that's at issue in this case is virtually identical to the stock standard that the industry itself adopted and successfully implemented, again, for stock products in 2008. And the industry adopted that voluntary standard because it is undisputed that operating cords on window coverings have the potential to be extremely hazardous to young children. And so properly framed, the overarching question in this case is whether the commission had a lawful basis for determining that products that pose an equivalent risk of strangling and killing children, custom products, could be subject to the same standard, or whether the commission had to be satisfied with half measures offered up by the industry. Again, it is not disputed that these products can be extremely dangerous. I want to talk about the incident reports and the data on which the commission relied, because my friend on the other side suggests that the commission was wrongfully relying on data that that related to products that are no longer at issue or that rely on free-hanging cords. What the commission did here was take the universe of incidents of which it was aware and then narrow that down to incidents that would not be addressed by the stock standard. It tried to analyze only the incidents attributable to custom products. And so, yes, it relied, at the outset on a larger universe of incidents, but then it narrowed that down. and only focused on the incidents that it thought were going to be governed by this rule. And that's,
So
that's
why not?
consumer products.
Why not give over the information about the incidents? Because it's pretty striking that the entire predicate for the rule, as set out by the rule itself, and totally understandably, is these incidents because of the palpable, horrifying safety risks. So I completely understand why the commission would have focused on that in detail and did the breakdown that the commission did. But it just seems like typically in these kinds of situations where there's underlying data, underlying analysis, underlying studies, that's turned over so that it can give rise to the kinds of intelligent comments that then will assist the commission in forming the rule. And that just didn't happen here.
Your Honor, what the commission did here was offer a several-page long discussion of the incident reports in the notice of proposed rulemaking. And that is in the record at JA 61 through 60.
Yeah.
And that was a lot of information for the industry to respond to. I think it's also, it's noteworthy here that even after
That was some, that is some, that's true, but it's not the underlying materials. And we know that because, I mean, you did produce a spreadsheet later on that had additional information, but isn't it, what's the problem, other than the confidentiality point, which we can get to, but some of it's based on newspaper reports, and there's nothing confidential about a newspaper report. And so why not give over the information?
Your Honor, I can't speak to why that wasn't done during the rulemaking, but again, I think it's important to bear in mind that even after the industry did receive a much more detailed spreadsheet, identifying the facts of which the commission was aware, the type of incident, the year, the age of the child, all of that information. It's not like the other side in their brief is going through line by line and suggesting that these individual facts really affect the commission's analysis. And so if there was an APA error there, and we would submit that there wasn't, it was not prejudicial to the industry. The industry
Well, suppose the spreadsheet had never been produced, we'd be in exactly the same place, right? Vis-a-vis the rulemaking.
Correct.
Because that was all done in litigation.
That's correct. Although I think the fact that even after receiving the spreadsheet, the industry didn't feel the need to discuss it really in any detail at all in their submissions to this court is evidence that they didn't need it to intelligently comment on the rulemaking process. I would also just highlight.
But maybe they just think that, well, we have some information for the spreadsheets, and they could think one of two things, maybe both. One of which is that we have some, but not a ton, or line items. And secondly, that can't salvage the rulemaking process because it can't be that it's okay not to turn over everything. And then after the rule's done, turn over everything in litigation and say, well, then there's no harm, no foul with the lack of turning information over because you didn't explain to us now what you would have done with it.
Right, and I don't mean to suggest otherwise. What was in the rulemaking record is what was in the rulemaking record. We think that what was in the rulemaking record was sufficient because it gave the industry an adequate basis to comment on the rule. It provided the important factual information that they needed. But if the court is concerned about that and doesn't buy what I'm selling on what was provided during the rulemaking, then the fact that the industry did receive more data later in the process in litigation and didn't think that it was particularly noteworthy or noteworthy enough to discuss in its brief to this court is evidence that there was no prejudice from the purported APA error, an error that, again, we would submit does not exist.
It's hard to know what the prejudice is in a situation in which the problem is we don't have information with which to make comments because it's hard to display prejudice when the whole problem is a lack of information.
And I think, Your Honor, again, the point I'm trying to make on prejudice is that having received more information, having received the spreadsheet, following the initiation of litigation, the industry didn't think it was worth discussing in its briefs to this court, which suggests to us that they had received really the bulk of the information that they needed to make an intelligent presentation, both to the commission and the court. If I may, I'd like to take a step back and try to talk about some of the fundamental flaws in the voluntary standard that was in effect at the time that the commission was actually undertaking rulemaking. And that was the 2018 voluntary standard, not the 2022 voluntary standard. I think the court appreciates this, but just to highlight the point, the 2022 voluntary standard did not exist as a draft piece of paper at the time of the notice of proposed rulemaking. And it didn't exist as an implemented or adopted standard at the time of the final rule. So to start with the 2018 voluntary standard, That standard has several features that are highly dangerous to children with respect to custom products, which is what we're focused on here. The first, the most meaningful really, is that it doesn't impose an actual enforceable limitation on the length of the operating cords. There's a default limitation of the cord length of 40%. That itself is dangerous, but more importantly, it can be overridden by the consumer. So the consumer or the installer can say, thanks, that's very nice, but I'd actually like to buy a cord that's significantly longer. We don't take the industry to really disagree that the 2018 standard was inadequate, since they have moved themselves to replace it. But it was hardly unreasonable for the commission to reach the same conclusion. Turning to the 2022 standard, which was again adopted following the approval of the final rule, it too includes numerous dangerous features that the industry itself would not permit to be sold on stock products. So starting with continuous cord loops that depend for their safety on the proper installation of external restraining devices. Again, the industry will not sell you that on a stock product. And the reason is that they're dangerous. First of all, those restraining devices, even though they're pre-installed, can be removed from the loop. And the commission was aware of at least one specific incident in which that happened. That's discussed on JA 23. But even if the consumer doesn't take the step of actually removing the tension device, so long as that tension device is not properly installed on the wall or it falls off the wall, it's still possible for the window covering to be operated partially. That is to say, you can raise the window covering, halfway up. And again, the commission was aware of an incident in which a child was injured that had a tension device like that was on the cord, but not properly anchored to the wall. And so that demonstrated to the commission's satisfaction, based on real world evidence, that this was not a sufficient incentive for the consumer to actually properly install these devices on the wall and ensure the safety of the children who are meant to be protected by these.
And that was spelled out in the proposed rulemaking, or that was spelled out in the final?
Well, Your Honor, the sites that I'm offering are from the final rule. And that's because, again, the 2022 standard did not exist at the time of the notice of proposed rulemaking. It did not exist now.
So it seems to me that certainly your agency is entitled to make a judgment that what's in the voluntary standards isn't safe enough and you want to go further. The question is just whether the procedures you followed were appropriate to make this rule,
yes,
and whether the effective date you set was reasonable. And it seems to me that the effective date is something that you should address, because there are strong arguments that you needed to show that it was reasonably necessary to set this date in order to protect safety, but there's not substantial evidence to support that finding. And it does seem to me that your data about safety wasn't really geared towards this finding, because this finding dealt with, should we do 6 months or a year and a half or 2 years? We're talking about a short amount of time, but your data was based on over 10 years, all of the window coverings out there. We have yielded about 8 deaths per year, and it's not clear to me what was the evidence to show that it was reasonably necessary to set the date that you set.
Well, I think, as Your Honor alluded to earlier, the commission was concerned that every unsafe product that is installed in a home could remain there for decades. And so every month that elapses is more unsafe products being installed. But I think it's important to emphasize that Congress placed a heavy thumb on the scale of these of these standards coming from the commission, taking effect within 180 days. And Congress required that if the commission goes beyond that 180 days, it needs to make a finding of good cause in the public interest. And the commission explained at some length why there wasn't good cause in the public interest to deviate from the policy choice.
I understand that, but what about the other requirement that you have to show that it's reasonably necessary?
Your Honor, the commission did make such a finding of reasonable necessity. That's at 16 CFR section 1260.4 F6.
Yeah.
So the commission did make that finding.
No, I understand, but how is it supported by substantial evidence?
Your Honor, again, it's supported by substantial evidence because of the risk of unsafe products being installed, which poses a continuing risk of suffocation and death to children.
But I think that the question is there a meaningful difference for safety between setting it in 6 months versus in 2 years or in 1 year, given that there were a lot of countervailing considerations about
Your
how
Honor,
disruptive this was, and your own staff acknowledged that.
Your Honor, the commission was not persuaded by the industry comments or certain aspects of the staff analysis.
But it didn't explain much about that, I have to say. I mean, JA34 is the relevant reference, and it walked through a handful of points,
Right.
which are stated at a high level of generality, and only some of which you're relying on now, some of which you're not relying on now. But in terms of the benefits, there was indication from the staff that the benefits of having 6 months rather than 2 years were pretty minimal, given the amount of old equipment that was already out there. And there's no engagement with that. And so as far as I can tell, in the commission's explanation, the commission's explanation is about costs.
Again, Your Honor, I think the commission's explanation was focused on the fact that Congress had told it to implement these safety standards within 180 days. And so principally it was looking for, good cause in the public interest for why it would tell Congress thanks but no thanks and not do what Congress told it to. And it was not persuaded that there was any reason for it to deviate from Congress's instruction. And again, just
So are you conceding then that you were really looking at the good cause provision and not really focused on the reasonably necessary?
No, Your Honor, the commission made both findings, but we do think that it's important, again, under the good cause provision, to honor the statutory presumption that Congress enacted. Just to take a step back here, what the commission was looking for was not a moonshot. It was not expecting the industry to cure cancer in 6 months. It was saying that in 6 months, it needed to start adding a few pieces of plastic and metal to its window covering boards. And the commission was not persuaded that the industry was not capable of doing that. The Canadian example, I think, is particularly helpful here because the industry had told the Canadian governments that there were no viable solutions to replace proven safe products on Canadian shelves. But then what the commission found was that that was in fact not true, that the Canadian market was able to accommodate the transition to safer products, just as the American industry was able to accommodate the transition to safer products in the stock market. So we've seen this movie before.
How long was there to comply in Canada?
It was a little bit longer, Your Honor. But with respect to the stock standard in the United States, that standard, I believe, was initially released in January, I think, of 2018. It was updated in May of 2018, and then there was compliance by the end of 2018. So that was, somewhere in the range of 6 months to a year, depending on how it's defined. Here we're talking about 6 months, which is again is not that different from what the industry has shown it's been able to do in the past. And particularly here, we're in a universe in which these technologies have begun to be developed because the industry has come up with technologies that comply with the Canadian standard, comply with the stock standard. And so it's not starting from zero.
So can I ask you kind of a factual window coverings question?
You can try. Yes.
It seems that your arguments about compliance seem very centered on the rigid cord shroud. And to you, that's like a piece of plastic. They can make that. That's not a big deal.
Right.
But your friend on the other side says you are trying to analogize to stock window coverings. And there we have things that, you can just lift up with no cord. We can't do that readily on a custom product because it's so much bigger and heavier. And it's going to be really hard for us. And it's going to take us some time to be able to develop products that are similar to the stock products. And therefore, your analogy to stock products is not really apt.
Right.
And I guess my question is, if your position is rigid cord shrouds do the trick, and it's easy for them to do that, is it true that they could do rigid cord shrouds for everything while they're developing the other types of things like the self-lifting shades, et cetera?
Yes, Your Honor. I'm looking to see if I have the site in my notes, but the commission did explain that rigid cord shrouds can be used to go to shroud, in effect, either the traditional cord lock type of cord or the continuous loop type of cord. And so a rigid cord shroud can be used for either type of covering. And the commission explained
that works for everything. That converts everything to compliance, the rigid cord.
a rigid cord shroud. Well, a rigid cord shroud, I don't think would be used with a retractable cord because that retracts into the headrail. But the commission did explain that a rigid cord shroud can be used with either a continuous loop cord or with a retractable cord.
And so how are they supposed to deal with the retractable one in the time frame that you proposed?
Well, Your Honor, the commission does not require the industry to develop, every mode of complying with the rule. So
No.
long as it's able to sell products that comply with the rule.
I understand, but it's part of your reasonableness argument that they just have to make some plastic parts here and
Right.
add it to the cords. And I'm just wondering how easy is it in terms of your reasonableness argument that they can address the retractable cords?
Well, Your Honor, what the commission said was that, there already exists cordless products cordless options for all kinds of products, but not for all kinds of sizes, not for all sizes. My friend on the other side references, very large window covers.
For which rigid cord shrouds don't work, right?
For which rigid cord shrouds do work, excuse me, Your Honor.
I thought there was a length after which they don't work.
My understanding, Your Honor, is that they may need to be made of metal rather than plastic in order to satisfy the deformity requirements in the rule, but that a shroud can be made longer or shorter.
And in terms of how, I thought the staff, there's a statement in the record to the effect that the staff thought it would take 2 to 2.5 years to make.
The staff recommended a longer effect.
But with respect to the manufacturing of the rigid cord shrouds in particular,
Right.
not on just the general 1 to 2 years, but on how quickly the rigid cord shrouds could be.
Your Honor, that may well be, but the commission was not persuaded by that analysis. Again, against the backdrop of having seen the industry come into compliance with other similar standards over the past several years, it was not persuaded by that contention. I'm happy to jump really to any issue the court would like to talk about at this point, or if there are no additional questions, just sit down.
Any additional questions?
I guess the jurisprudential question of assume for the sake of argument that we find merit in one of the arguments made by the petitioner. Is there grounds for partial vacature, or based on the statutory language, do we vacate the entire?
I think it would be more consistent with this court's general practice to partially vacate on the issue where the court identifies a legal flaw, presuming it is any. The language about the rule not being affirmed unless various things are found by substantial evidence simply suggests to us at least that the court wouldn't affirm the rule in its entirety. That wouldn't preclude the court from vacating it if that were the court.
I take it from the commission's perspective, though, put aside the constitutional argument for a second, the removal power argument, but from the commission's perspective, it would be more instructive to have a sense of how all these arguments shake out, so that if we were in the world where the rule went back to the commission, then it would have an informed basis for putting together a resolution.
Your Honor, I don't know that we've expressed a preference on that one way or the other. I think, we would defer to the court as to how it writes its opinion, except we would like it to deny.
Sure. Yeah. That I would assume would be your favorite position. But
Indeed, yes.
So if we found an issue, for example, with your failure to provide the data underlying the incident reports, and we remanded to allow notice and comments on that, that would not reopen the process from your perspective on things like the cost benefit analysis.
Correct, Your Honor. That is our view.
So doesn't that counsel towards us addressing all of the issues? Because let's suppose we stopped at issue number 1 and we did what you would like us to do, only a partial vacature, and the commission adequately resolves issue number 1. The petitioners can't come back to us on another commission and raise issue number 2, which was raised before, because that wasn't a part of this rulemaking or the order that's under review.
Of
Right?
limited.
So they if there had been merit to issue number 2, it would have been essentially overlooked, and they would have no opportunity to raise that issue in a subsequent petition.
I take that point, Your Honor. I think what we'd like to avoid, assuming the court is inclined to remand at all, is a situation in which the court remands on one issue, and there's a fight about having to redo the entire rulemaking. We don't think that would work.
Right. I mean, you don't want to get in a ping pong situation where it just keeps coming back up and going back down on the next issue,
Of
and then
course.
comes back up and then goes back down on the next issue.
Correct. Although
That's not-
we'd also like to avoid a situation where the industry, continues to tweak its voluntary standard. And then the commission is expected to redo an entire years-long rulemaking each time it gets remanded to the court. All the more reason for this court to deny the petition for review and get a second.
Understood.
No further questions? Thank the court for your time.
Thank you, counsel.
Thank you.
Mr. Harsky will give you 3 minutes for rebuttal.
Thank you, Your Honors. I think just a few quick points. First, to go back to one of Judge Srinivasan's questions, this was about the additional costs of custom products. My co-counsel helpfully pointed out to me some pages in the J the court might look to. JA pages 720 to 721 have very specific comments about how the custom products cost more than stock products. There are also some more general citations about custom products being costing more at JA 735 and 850. And then I would also note that in the rule itself, 16 CFR 1260.4 D4, the commission acknowledges that custom products cost more than stock products. So just wanted to make sure we had that squared away. I'd also like to address the effective date and some of the questions that were asked about the rigid shroud. Just to be clear about that, the shroud is only a proposed solution for the cord loop type. So under the rule, there are 2 types of operating systems that are allowed. There's the retractable where you pull the wand, and there's the cord loop. The idea for the shroud that the agency has is that it's a plastic piece that has to go over basically the whole loop. And so they estimated a cost for one shroud that they think will solve the whole problem. That doesn't address retractable, because for retractable, the products have to be remade with a different cord length. And also, we don't think it just makes any sense to say that one shroud resolves all of the types of the cord loops that exist, because the shrouds have to be like different sizes. I mean, some of these windows are 10 feet tall, and you're talking about different pieces of plastic that have to be manufactured that haven't ever been designed and manufactured before. So I just wanted to correct that it is the staff that said that the rigid shroud would take 2 years. They call it a little piece of plastic. We call it, a requirement that's never been put on the industry before, that no one has designed and manufactured. The staff said that that's going to take 2 years, and that only addresses the cord loop solution. It does not address the rules they put on retractable. And
What percentage are retractable versus cord?
I don't know. I don't think that exists, that information is in the record, but I mean, they are products that are allowed under the rule. I mean, we're talking about some windows that are so big that they need cords so that you can't use the cordless solution. And so retractable remains an option, and then the cord loop remains an option. And another thing I would just note about this retractable system, we've highlighted some of the process failures that we see here in terms of stuff showing up for the first time in the final rule, including new incident reports, including the analysis of 2022, et cetera. But one of the things that actually showed up for the first time in the final rule was the substantive requirement for retractable products. These are products that have had no known incidents. And for the first time in the final rule, the agency said, now the cord can only be 12 inches long. So we just think that that's, another example of the process failures here. And so I guess the last thing, if I see my red light is on, I promise it'll be brief, is, obviously we're
It's
all
orange right now, but it's about to be red, so go ahead.
We're all focused on risk here, and we just don't think that the agency has assessed it in the way that this particular demanding statute requires. Even today, the approach in court has been to talk about possible risks, but the case that we think that is most on point here, this Zen Magnets decision from the 10th Circuit says, no, it's not possible risk that you look at. It has to be a likelihood of risk here that you assess so that you can do this cost-benefit analysis. And here you've got the agency admitting that it has found no risk for whole segments of the market. The retractable products, no incidents. Commercial products, that's 25% of the market, no incidents. And so, of course, we're concerned about harms to children. That's why we've been working on this since 1996, and we've been the ones updating this voluntary standard. And so we're not saying that the agency doesn't have any ability to regulate here, but it has to go through and do what the statute demands. And it just didn't do it here. And it's not fair to subject this industry to a rule that would go into effect in 6 months and cause hundreds of millions of dollars of damage when they haven't even complied with those basic requirements.
So on the cost benefit analysis, that seems to be a very commodious. This has to have a reasonable relationship. The benefits don't even have to outweigh the cost. It just seems to me that there's so much play and give in the standard that it's more difficult to make the argument that that cost benefit analysis, what they did, because they certainly spent time and did analysis and made ranges and said there are some other factors that we could consider. But it seems like they did the work and it's a very loose standard. So why is that cost benefit analysis not okay?
Well, I think there's three responses. And at the bottom line, I think, is that we think they didn't do the work. So you're right, that it's reasonable relationship, which we think requires some kind of proportionality. We think that the costs were skewed, the benefits were skewed. And then even with those skewed numbers, they ran 30 scenarios and the benefits only exceeded the costs in one of them. In some of the
But they don't
scenarios,
have
the
to
costs
exceed
were.
the cost.
Right, but I'm just trying to say that, it wasn't even like proportional in, 29 of the 30 scenarios. And I guess the problems that we see, in terms of your question about whether.
What do you mean it's not proportional in 29? I mean, I know that the benefits didn't outweigh the cost in all of them, but I don't
Right,
think that means it's
a
not
range.
proportional.
There's a range in terms of how much the cost exceeded the benefits. Sometimes it's 135%, sometimes it's 400%, but it's a pretty significant range where I don't think like 400% more cost than benefits would be considered proportional. But I guess maybe the more fundamental point, to go to your honor's question, is that we don't think that they did the work here. This isn't like second guessing or nitpicking the agency's analysis. It's that, fundamental parts of the analysis were either missing or skewed. And what I mean by missing is that you've got like a complete lack of safety incidents for retractable cords. No benefits there that they have identified, and yet they're regulating them anyway. You've got no consideration of costs for the commercial segment of the market. That's 25% of the market. That's like a part of the rule. It says that the agency has to figure out the number of products affected. And they didn't even do that because they I think acknowledged that they didn't even consider that 25%. And so that we think that that's just like a missing analysis. And then when I talked about the skewed analysis, one of the things that I think the discussion identified earlier was to figure out the cost, that it was all based on stock products. And there were the questions about, how much more expensive custom products are, et cetera. So assumptions being made that really skewed the costs in terms of basing them on stock products, and then also really skewed the benefits, basing it on data from 2002 that even the agency is now, admitting that the number of incidents that occurred, decades ago don't occur anymore because of these voluntary standards. And so I take your honor's point that you don't want to be second guessing the agency here if it's doing, a reasonable job with its cost benefit analysis. But, this isn't a normal APA case where Congress just said, like, figure out what you want to do and give us some evidence that shows that it's reasonable. Congress said, we want you to go through all these steps. We want you to figure out the degree and nature of the injury, the number of products affected, the cost benefit analysis, less burdensome alternatives, go through each of those steps. And when you have a cost benefit analysis that, skews the cost, skews the benefits, and then even doing it in 29 of the 30 scenarios, you really don't have proportional costs and benefits, or at least you don't have the benefits outweighing the cost. We just don't think that it meets that burden under the statute. It's just too far away from what Congress wanted to have happen here. And of course, where Congress has wanted to give more discretion to the agency, like with infant products like cribs and toddler products, it has passed different statutes to do that. But this statute is one that's more demanding on the agency.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-1597. Laura J. Ramos, appellant, versus Merrick B. Garland in his official capacity as Attorney General of the United States. Mr. Kuba for the appellant, Mr. Teep for the appellee.
Morning, counsel. Kuba, please proceed when you're ready.
Good morning, Your Honor, and may it please the court. David Kuba on behalf of the plaintiff appellant Laura Ramos. Your Honors, this case arises under Title VII of the Civil Rights Act. a statute and a title that was enacted largely to prevent discrimination and retaliation in the workplace. We respectfully submit that reversal and remand is necessary here to achieve those purposes. Ms. Ramos brought an action under Title VII after her employer, the Federal Bureau of Investigation, retaliated against her for filing a formal complaint with the Equal Employment Office in 2011. The district court erred when granting summary judgment on Ms. Ramos's retaliation claim. Now, the actions at issue here span past 2011. They go on for several years. I want to spend most of my time today talking about the events and actions in 2011, because I think those events and actions are sufficient alone to establish a retaliation claim that should have survived summary judgment. In May of 2011, Ms. Ramos filed an informal EEO complaint with the EEO alleging that her supervisor was discriminating against her in the workplace. In late August of 2011, she filed a formal complaint raising those same allegations. Around this same time, her assistant section chief, whose name was Edward Finnegan, had made an offer to Ms. Ramos to transfer her to a different unit, to the cyber counterintelligence unit. This would be a unit with a new supervisor, new coworkers, new work area, new opportunities, and new responsibilities. Ms. Ramos accepted that offer in an email on September 9th, 2011, and her new would-be supervisor began looking forward to and preparing for her arrival.
But she didn't really accept the offer because she said, I'll do it on, I think her words were, as an interim solution. Didn't she use the words interim when she had been told this is a permanent job? If you get transferred, that's your job until you find another job?
Your Honor is referring to an argument that the Bureau made after the fact to explain why it didn't view her email as an acceptance. Her email says, I accept your offer. If you look at the email that was sent to her, it explains what the offer was, and it expressly says, when you take this new position, you can continue to look for other job opportunities. So when Ms. Ramos says, I'll accept it as an interim measure, that's what she's telling him. Essentially, yes, I'll go do this and I'll continue to look for other job opportunities. If Mr. Finnegan had interpreted it the way that he said he did after the fact, one would expect he would have emailed her back and said that. And that's not what his email back to her said. He never mentioned that until after this action was filed. And
Does it matter whether she accepted it or not? Or isn't the point that there was an opportunity that was proposed, negotiations at most were going on, or she accepted and then it was just cut off from her?
It doesn't matter for two different reasons. One, at a minimum, we're talking about a factual issue, right? With respect to whether she accepted it. And two, simply taking away a transfer offer from an employee who's been trying to transfer out of her job because of discrimination would itself be adverse enough to support a retaliation. So her complaint was with this particular person, the acting chief, Diana Race. And I was just wondering, in the succeeding efforts to transfer, was Ms. Race still her supervisor, or she was only acting? So at what point was she gone? She was gone, I believe, in December. So not long after.
Of 2011.
Correct, in December of 2011. So not long after she would have filed her formal complaint. By November of 2011, there's email evidence from Mr. Finnegan describing Ms. Ramos as a known entity within her unit. There's other evidence that after that, people were aware of her having engaged in protected activity. And ultimately, whether Agent Race was there, even in August of 2011, we think it's still adverse action, because when you offer to transfer somebody, they file a formal EEO complaint. The next thing you do is rescind that offer and say, we're not going to transfer you. We think that is sufficiently adverse, regardless of whether her supervisor Race was still in that unit or not.
Just the Ortiz-Diaz case seems to couch this in terms of trying to get away from the discriminatory supervisor, having better opportunities. But the discriminating supervisor is no longer an issue after December of 2011.
Correct. I think that it is fair to analogize this case some to Ortiz-Diaz. Of course, there it was a discrimination case. Here we're talking about a retaliation case. The standard for an adverse action in a retaliation case is broader than it is in a discrimination case. This court recognized that most recently in Chambers, the Supreme Court recognized it in Burlington North v. White. In order to show retaliation, it really turns on whether or not a reasonable employee would be dissuaded from engaging in protected activity. We would submit that a reasonable employee would certainly be dissuaded from engaging in protected activity if it knew the cost of doing so would be to forfeit an opportunity to transfer from their existing unit. I personally think that would be true in just about any line of work, but the record here, I think, supports that it is absolutely true somewhere like the FBI, where agents depend on transferring to other units to develop their career. It's normal, it's commonplace. And so when you take away the ability to transfer from an FBI agent, you are necessarily harming their career prospects, if you will. So just to take a step back, there are 3 requirements for a retaliation claim. There's no dispute here that Ms. Ramos was engaged in protected activity. We don't think there could be any reasonable dispute that the FBI's decision to take away her transfer offer or to not let her transfer after she accepted it, whichever way you want to interpret that. We think there is sufficient evidence that that was causally related to her protected activity. In a lot of Title VII cases, sometimes it's hard to show that causal connection between a protected activity and an adverse action. Here we have direct, unrefuted evidence that Mr. Finnegan told her in no uncertain terms, we're not going to transfer you because you have filed your formal EEO complaint. So
Can we move on to the other claims at issue, the temporary reassignment to backup program manager and the, I guess, denials of transfer to Boston and New York and IOD? For those, who were the decision makers, and is there any evidence that was presented that those decision makers were aware of her EEO activity?
Sure. A lot of times in the record, it's not exactly clear who's making the decisions, but just to focus on the removal of Ms. Ramos's supervisory responsibilities over the double agent program, the person who announced that change was an individual named Mr. Jett. This was in 2013 that he announced it, March of 2013. Agent Jett had submitted an affidavit as part of Ms. Ramos's formal EEO complaint, the investigation process there in 2012. So I think it's fair to assume he was aware of her protected activity.
Okay, what about the others after the IOD and Boston and New York?
Sure. Again, there is evidence in the record that Mrs. Ramos's chain of command were aware of her protected activity. In May of 2013, a litigation hold memo went around to all the employees who'd worked with her, who basically said, she has filed this complaint in federal court. I think, I don't want to get the month wrong.
When is the date?
July of 20, pardon me?
The litigation hold went out when?
May of 2013. She filed her complaint of March of 2013, mid-March. It was served mid-March. End of March, she was removed from her supervisory position. May of 2013, the litigation hold memo went around. She was denied transfer kind of around the same time. In July of 2013, she had a conversation with her then acting unit chief, who said he was aware of her EEO complaint, who was aware of her federal district court complaint. And another individual, either her acting unit chief or assistant unit chief, mentioned that he had spoken to the EEO about it. And at one point even told her that she was not allowed to talk to the EEO without clearing it with him first. So I think there's sufficient evidence to show that her superiors were aware of this. In fact, this goes all the way back to 2011, right? When in November, her assistant section chief, Mr. Finnegan again, described her as a known entity and not as a way you'd want to be known, is what the email said.
On the question of whether those decisions were retaliatory, so with the Boston and New York transfers, denial of the transfers there, the ultimate basis for the decision was because of a lack of seniority. I think that's hard to
The
that
Boston
wasn't-
and New York were because she didn't meet the criteria because she had received a negative performance
Oh, that's right. That's right.
evaluation.
I'm sorry.
Right, but
Yeah,
you're speaking
yeah.
about the IOD.
The IOD
transfer,
the
of
IOD
course.
one was, yeah.
Of course. And in that one, it was, what they say in their brief is that it was a lack of seniority, but they refer to the Deputy Assistant Director Smith's decision to select an individual, Agent Larson, over other candidates. But Deputy Assistant Director Smith didn't have Agent Ramos, Ms. Ramos, as an option because the IOD transfer was a two-stage process. So the first selection, the first decision was made further down the chain of command, closer to Ms. Ramos, and they selected Ms. Larson over Ms. Ramos. We sought discovery on the reason for that selection. We never got discovery on it.
So I guess that has to do with Brooks, I think. And I guess I didn't see anywhere in your opening brief where you actually made an argument specific to that IOD transfer swap. Is that a swap or transfer? I can't remember. Denial on retaliatory motive.
Well, I think our claim would be that it was retaliatory because it was based on protected activity. They chose not to transfer her because they were retaliating against her for engaging in protected activity. That was the motivation for it. I'm not sure I follow your.
I guess I didn't see anything in the opening brief that gave a reason why we wouldn't accept the government's argument that there's no genuine issue as to what the basis of the decision was. It didn't have to do with retaliation. It had to do with.
Well, I guess our point is that the government's response that it has to do with seniority is focused on the DAD Smith decision, the second level, whereas the real discrimination that we allege, the real retaliation, that we allege occurred at that first decision level.
But you don't have any evidence about what happened there. You say you sought discovery and didn't get it, but that's not one of the grounds for your appeal. You're not saying that the district court should have granted a motion to compel that we had for discovery on that second level, so to speak, right?
Right. No, that's not our argument. And we asked the decision maker there.
Then how are we to find that it was discrimination, that you have evidence that was discriminatory when you say you don't have any evidence about how that was done?
Right. I think we would rely on decisions that have held that when the plaintiff comes forward with evidence that adverse actions were taken in close temporal proximity to protected activity, that is sufficient to push the burden back on the government or the other side here. And they haven't come forward with any evidence of a non-retaliatory reason that really withstands scrutiny. The only non-retaliatory reason they identify in their briefs, as they did below, is this idea that DAD Smith selected Larson because she had more seniority. They never offered any evidence as to why the decision was made by Ms. Ramos's more immediate superior.
Right, and I guess that none of that is in your opening brief.
Okay.
That's my only point, is that you engage with that in your reply brief because the government makes the point. But in the opening brief, the argument is really about spillover retaliation from what happened in 2011, which is an argument.
Right.
It's not that it's not an argument. It's just that the particular argument you're making now, which is to controvert what the district court and the government relied on below, i.e. seniority, just wasn't in your opening.
Okay, I apologize for that. I thought we did raise in our opening brief the protected activity that was in close temporal proximity to the decision not to transfer her.
Yeah, the temporal proximity, but all I'm saying is
I understand.
That doesn't have to do with the first stage, second stage, and the particular reason that seniority isn't a valid basis.
Right.
That's just saying that in order to infer retaliation here, all you need to do is look back and see that there was retaliation at the outset in 2011, and that continues to carry forward.
That's fair, Your Honor. I understand, and that's fair. We did not make that argument in our opening brief. We made it after the government raised it in its opposition to try to explain the lack of retaliatory.
And I guess here's my question about the notion that what happened in 2011 continues to carry forward, and we ought to kind of see the taint as applying on a limitless basis going forward, which is that suppose we agree with you on 2011, just for argument purposes, let's suppose we agree with you. The explanation given by the supervisor was that there's an active EEO investigation going on right now. And while that's because you filed a formal complaint, and while that's going on, I'm just going to play hands off. And But that explanation in and of itself is temporally limited. So it's not the type of thing. It'd be one thing if the record were that we really dislike you because you filed an EEO complaint and the whole division is against you because we don't stomach this. You know, you're being disloyal, and that's not going to happen. Then that type of thing, I could see why you could say, well, that continues to go forward, and when does that stench ever get removed? I don't know. But this one actually, by its very explanation, was tethered to that particular process.
I think that's fair, Your Honor, insofar as if our claim was only that, let's say, she didn't get a transfer in 2015, and our only evidence that it's retaliatory is that 2011 email, and the EEO process is completed, everything's completed about her 2011 complaint, then I do think there comes a point where you could no longer rely on that 2011 email, that explanation and that refusal to transfer. There does come a point where you can no longer rely on that. I don't think we were at that point in 2013. I don't know if you could rely on that alone, if that was all the evidence you had for retaliatory animus. But again, she didn't stop engaging in protected activity, and people, her coworkers, people in her chain of command, didn't stop being aware of that protected activity in 2011.
But nobody after that, I mean, there's no indication that for any of the protected activity that occurred later, that the reason for denying whatever was requested, like a subsequent transfer, had to do with the pending nature of some EEO complaint in the same way that was the case in 2011. And I don't even think you allege that.
No, we don't allege that, and that's correct. We do not have the direct evidence of causation for the 2013 and 2014 alleged activity that we do for the 2011 activity. For the 2011 refusal to transfer Ms. Ramos, we think there's irrefutable evidence of causation there. For the later retaliatory action, we rely on more circumstantial evidence to try to create an evidentiary issue that we think was sufficient to at least reach the jury.
On the Boston and New York transfer denials, so the stated basis is that the eligibility criteria weren't met because of the 2013 performance review. And why isn't that just dispositive?
Right. I understand your question, and that is a hard case for us, but I don't think we would want to waive that argument, because here the criteria is directly tied to what we alleged below as retaliatory actions. When Ms. Ramos received reviews, annual evaluations, she received an evaluation from a supervisor who'd been her supervisor for less than 6 months that was considerably lower than anything she had received before. The FBI then relies on that as the basis for denying a transfer.
And didn't you move to amend your complaint to challenge the performance ratings?
Exactly. We sought to bring that in as a separate allegation of retaliatory conduct. The district court denied that. And then it allowed the FBI to, pardon me.
I'm sorry. But for purposes of the transfer request, they relied on the performance evaluation, and that seems dispositive of the transfer request. But you could, if you were allowed to amend your complaint, independently challenge the performance evaluation.
That's exactly right. And that's really why we would preserve our argument on this, because as it is, the FBI was able to keep out the performance evaluation at the pleading stage, and then later on in the proceedings say, oh no, we didn't transfer her because she had this bad evaluation.
But you'd have to win on being able to allow and on getting a reversal of the denial of amendment.
Right.
Leave to amend your complaint.
Yes. In order for that, I think that's ultimately correct.
So why didn't you raise that earlier? Why didn't you try to challenge the performance evaluation earlier? Why did you wait?
You mean, why did we seek an appeal on that before this appeal?
No, I'm now talking about your motion to amend your complaint.
Okay.
It was denied by the district court, and one of the factors for that is your timing. Why did you move to amend with respect to the performance evaluations at the time that you did, instead of raising it earlier in the case, perhaps in your first complaint?
Right. I don't know if there have been a few different amended complaints and a few different motions to amend that were denied. We did have a couple of complaints that were denied because we hadn't exhausted the administrative process yet. So Ms. Ramos filed additional EEO complaints, as I referred to, the additional protected activity. We tried to add those allegations, those alleged acts to our complaint before the EEO process had been completed. And the district court said we couldn't do that. So
when was the EEO process exhausted? Was there an EEO claim made for the negative performance evaluation of 2013, right? That's the year of the performance evaluation.
Correct.
Right?
It may have been early 2014, Your Honor. And I don't want to misstate the record. I cannot recall if that was part of one of her EEO complaints. I suspect that it was, because Ms. Ramos was very diligent when it came to getting things in front of the EEO and trying to preserve her rights. But I don't want to say that without being 100% sure of it. But I know it for certain.
Well, in the district court's denial of your motion to amend, she didn't accuse you of being dilatory or anything.
Right.
That wasn't one of her bases. So.
That was one of her bases.
No, it was not.
It wasn't. Okay.
It was not.
Thank you, Your Honor.
Yeah.
I didn't think it was, because she was the one who had us complete the administrative.
But she did
process.
conclude it was unduly delayed. She did cite the undue delay criteria. Right?
I don't think so.
In denying you leave to amend the complaint.
No, I think she did say it was late in time, but not unduly late. So in other words, at one point she denied a motion to amend because she said a lot has happened. You know, we're at the close of discovery. These events happened later, but she didn't say that we had, dragged our heels or done anything improper in terms of moving to amend. Because again, we moved to amend.
I thought she specifically referenced undue delay, but I could be wrong about
Well,
that.
she definitely referenced that there would be prejudice, and I thought that the district court said undue delay. But cut to the heart of the matter, you've got to convince us that there was an abuse of discretion. What was the abuse of discretion?
I would say the abuse of discretion began with the way that she treated the retaliatory conduct in 2011.
Oh, no, I think
On the motion, the denial of the motion. For
The denial of the
amend.
motion to amend.
Yeah.
I guess we would just say that under the standard for amendment, which is typically freely given, of course, that freely given leave becomes less so as the case goes on. We would just submit that clearly these events are related to the events that are in the complaint. We're talking about the performance evaluation today as a basis for them denying a transfer. That's part of our complaint. So her conclusion that they weren't sufficiently related to be part of the complaint, we would say was an abuse of discretion, as subsequent proceedings have sort of.
that's another item which you can correct me if I'm wrong, and you can correct me on rebuttal if I'm wrong. And I never mind being corrected. I thought in the opening brief, I didn't see an argument
whether it was sufficiently related.
that it was unduly delayed and unduly prejudicial to add these allegations of that.
No, I don't think we challenged that. I'm not sure that the court had ruled that way against us.
So if I may, I'm looking at the transcript now, and it seems that in the context of undue delay, she said that granting your motion would unduly delay this action or cause undue prejudice. She wasn't saying that you unduly delayed in filing your motion on these claims. And I think that's an important distinction.
Correct. And that's my recollection as well. And if we were speaking past one another, Your Honor, I'm happy to address the question of whether it would unduly delay the proceedings and not whether we unduly delayed in seeking leave to amend. I think.
But she found undue prejudice.
Pardon me?
She said it would be unduly prejudicial.
To the government, correct?
Yeah.
But not because of anything we did wrong. I guess I don't know where the prejudice is, especially given the length. We're already talking about a long time since the events took place. It would be nice to have all of the various acts that were taken against Ms. Ramos treated in a single case so that she didn't have to file a separate complaint. She has a second complaint pending now about some later retaliatory acts. I'm not sure, really, granted that discovery had taken place, but we hadn't sought, obviously, since we hadn't had our complaint amended, we hadn't sought any additional discovery on these new allegations or claims. I'm not sure that it would have really created a whole lot of new work, but that doesn't seem like a good basis for a good basis for denying leave to amend for in the abstract. I think that would have been a better thing to.
I mean, isn't the general point that look, I have a summary judgment motion, which if it has merit, will end the case. And I have a motion to amend the complaint, which if I grant, means that I can't resolve this case and get it over with. We have to go back and do discovery, et cetera, et cetera. And it's going to be another year before I can resolve it. And, you know, all good cases must come to an end, you know, good or bad. I mean, isn't that basically what the district court is saying? And why isn't that just, I guess what I'm trying to find out is like hone in on if our standard of review is deferential, which is what an abuse of discretion standard is, where is the abuse there?
Right. Taking it back to the beginning of your question when you spoke about resolving summary judgment, I guess one is we never thought, obviously, that summary judgment should have been resolved against us. I don't think our motion to amend preceded, briefing being finished on the summary judgment motion filed by the government.
You think it was filed before the summary judgment briefing was finished?
I know it was filed before. Yes, it was filed before the summary judgment briefing was finished. There were certain delays and stays in the case. And was it filed before the opening brief for summary judgment? I think so, because I didn't see anything from the government, moving to strike it or saying, hey, you can't amend your complaint on to a summary judgment. I don't know that we were.
I thought discovery was still open. I could be wrong, but that was my recollection.
That may be right, too.
The timing is important.
Right.
I hated nothing more as a district court judge and seeing a summary judgment from one side and then getting a motion to amend from the other side.
Yeah, I can appreciate that.
I thought we were at the point where we're going to.
As a practitioner, I hate getting a motion to amend after filing a summary judgment. So I can totally appreciate where you're coming from on that.
Could you check your records and answer that on rebuttal?
Yes.
Explain the timing of your motion to amend.
Yes.
Whether discovery was still ongoing and whether the timing of it was due to the fact that she had at that point exhausted her claims.
Right.
And the relevant motion to amend with the 2015 one, because there were other ones. There was one of them that doesn't matter anymore because you filed a new lawsuit.
Right.
Or somebody filed a new lawsuit.
Yeah, I think if we're speaking about the 2015 one, I think Your Honor is right that discovery was still open. Certainly, they hadn't filed a motion for summary judgment on the entire case in 2015.
Sure, if my colleagues will have additional questions for you this time.
Okay.
Thank you, counsel. We'll hear
Thank you, Your
from
Honor.
the government now. Mr. Teep.
Good morning. May it please the court, John Teep on behalf of the government. I want to address a number of the arguments made by appellant and clarify the record. I'll start with the 2013-2014 transfer request by Ms. Ramos. I think the panel has hit on the right points, which are number one, that the actual decision makers for those transfer decisions, there's no evidence in the record that they had knowledge of Ms. Ramos's protected activity, or certainly not protected activity within the temporal scope that, the courts say, well, we can infer perhaps some retaliation because it occurs right after a protected activity. And so, for example, with the International Operations Division, it was a swap of supervisory special agents. The decision maker there was Deputy Assistant Director Smith. There's no evidence in the record that Ms. Smith was aware of, I guess in this point, this is October of 2013, that she was aware of.
Does there have to be specific evidence that a particular person was aware, or is it just enough to know that it was generally out there?
No,
That's gotta be enough.
According to this court's Talavera decision, you need to have evidence, at least at summary judgment. Now, if you're talking about a motion to dismiss and whether or not there's a prima facie evidence or a prima facie case has been made, but at summary judgment, you need to have evidence that the decision maker was knowledgeable of the protected activity, because otherwise the action of that decision maker would not be because of the complainant's protected activity.
We can infer that though, correct? And I want to ask you about when Ms. Ramos was temporarily reassigned from the DAOP program. She had been the program manager for that. She went out on medical leave. And she had been back for 2 months. And on March 19th, she serves the FBI with her complaint. Then on March 28th, Jet announces that Anthony Wagner is the new DAOP manager, relegating her to the backup program manager. And he says this was supposed to help her with her medical condition, but she'd been back for 2 months already at that point, and he waits until a week after she files her complaint to do that.
2 points, Your Honor. Number one, there's no evidence in the record that Mr. Jet was aware of Ms. Ramos filing a federal court complaint, number one. Number two, Mr. Jet had raised with Ms. Ramos while she was on leave in January, so before the alleged, protected activity that supposedly would be relied on for retaliation, and said, I'm being swamped because he was the acting unit chief, had his own responsibilities. He was taking on the double agent program responsibilities while Ms. Ramos was out. I'm getting swamped. I want to, bring someone in to help me out. And I understand Judge Pan saying, well, by the time that this actually happened, it was in March, but that's just a function of the fact that he couldn't find someone to do a temporary detail. This individual, Tony Wagner, he was going to be retired. He had time and availability, and so they bring him in. And they don't take away. Isn't this all
for the jury to decide? I mean, the timing seems like it could support her claim, and we could just let the jury decide.
Well, according to Woodruff Peters, timing is not sufficient if there is a legitimate explanation for the action. And here,
but the jury would decide that.
No, but the question here is, and again, that the plaintiff or the appellant has to come forward with evidence to rebut the explanation, to say that what Mr. Jet said was pretextual. And there's no evidence in the record to suggest that Mr. Jet was making up this explanation for why he was reassigning Ms. Ramos temporarily to be the backup while she recovered from her injuries and her medical leave. And so what we're saying is on the double agent program reassignment, there's two problems for appellant here. One is that there's insufficient evidence that it was taken because of her protective activity. And number two, as we've argued below, there's also no material adverse action here because one of the things that this court looks to in determining whether or not just a change in work assignments is material is, well, is there a significant difference and diminishment in the responsibilities? And while this program was Ms. Ramos's highest profile program, she did testify that she had other high profile programs. And so when you look at the entire context, it's clear that this was not a material adverse action as the district court had found.
But the materiality of the responsibilities is generally a jury question.
The standard by this court is that under Sokolsky, and has been supported in other cases, that there needs to be a significant difference and diminishment in responsibilities. And that's a question that this court can make. And so
in 2011,
yes.
So there's just evidence in the record that the reason that the transfer wasn't moved on is that she filed an EEO complaint. That's the government's own testimony, an indication in the email that she got. Why that has to go to the jury at that point, it seems like, because that is retaliation. It's not necessarily bad faith. I'm not suggesting that somebody bore ill will and thought that there was supposed to be a penalty here or anything like that, but it's just it is a reaction to the filing of a formal EEO complaint. And it just seems like, just as a matter of law, that at least goes to the jury because there's direct evidence the filing of the formal EEO complaint was reacted to by withdrawing a potential transfer that otherwise would have been made available.
Respectfully, Your Honor, the government disagrees. And there are two important points to make with regard to the 2011 transfer. First is that a decision here by Mr. Finnegan to defer to the formal EEO process is not likely to dissuade a reasonable employee from engaging in the EEO process. That's the test under Burlington Northern.
Really? So if somebody gets, if a supervisor just comes to a subordinate and says, here's the deal, you can file the formal EEO complaint if you want to, but I'm just letting you know if you do that, we're not going to give you your transfer. We're just going to let that play
But
out.
there's an important distinction in this case. This isn't a case in which Ms. Ramos was put in for a transfer and was denied for a transfer. Again, we have to start with where this all begins, and that is a complaint about Diana Ray's claim for discrimination that was made informally in May of 2011. What Ms. Ramos said is that to resolve my discrimination complaint, I would take a transfer. Mr. Finnegan, on his, he decided that he will try and find a transfer location for Ms. Ramos. He was unsuccessful, or at least there was, as Judge Wilkins stated earlier in raising the interim measure, there, according to Mr. Finnegan, there was not an acceptance of what he was offering, which was a permanent reassignment. And so what Mr. Finnegan told Ms. Ramos on September 9th is, I've been notified that the EEO matter has now been made formal, and the next step is mediation. Since there's now an official formal process underway to address the issue, I think the most appropriate course of action is to allow that process to determine where you go and under what circumstances. And so what Mr. Finnegan was doing was he was participating in the EEO process, trying to find an informal way of resolving this. That did not seem to work. At the time that Ms. Ramos had now, as of August 31st, filed a formal complaint, he learns subsequently that, hey, this has gone formal. The next process is mediation. I'm going to hand this off to the mediator. And what is, I think, also important for Your Honor to understand is that in that August 31st email, Mr. Finnegan.
So we have a case foreman that involved pretty similar situations. It also involved an EEO matter, and it also involved an explanation to the effect that it's not bad faith, it's totally good faith, but we're going to hold off on your request because of the EEO process. And we held that that goes forward.
Well, I'm not familiar with that case, Your Honor, but in this case, where Mr. Finnegan is handing off, and what I was going to say is that copied on that August 31st email is Peter Giancopoulos. He's the person that Mr. Finnegan identified as being responsible for the mediation. That is at JA 389. Days later, Mr. Finnegan provides Mr. Giancopoulos a download on the back and forth about his efforts to informally find a transfer for Ms. Ramos, and also provides his availability for mediation sessions. That's at JA 6110. Ms. Ramos actually withdraws from the mediation process, and that's at JA 1039. And so the context, and as the Supreme Court in Burlington Northern says, context matters. In the context of this case, what we have here is Ms. Ramos engaging in the EEO process, trying to have an informal resolution. The FBI is trying to do that, but it didn't succeed. And so what happens is the process moves forward. And so Ms. Ramos, in some sense, was left no worse off than if Mr. Finnegan had not even tried to provide a transfer option. The next step is the formal mediation process.
So in your view, it would have been fine if Mr. Finnegan went to Ms. Ramos and said to her before she files a formal EEO complaint, everything else stays the same. He goes to her before she files a formal EEO complaint and says, it's up to you. If you file the formal EEO complaint, I can't help you out with the transfer. It's up to you. You can file the formal EEO complaint if you want to, but if you do, I'm done with the transfer.
But that's not what he said.
But I'm asking you, could he do that? Would that have been fine, or would you still have the same argument, which is?
Well, again, I think it would be difficult for a reasonable jury to conclude that the man who has just spent a couple of months trying to find her a transfer then tries to interfere in the EEO process in such a way. But what I
thought what we were talking about is whether somebody would be dissuaded. And I
Right.
guess what I'm putting to you as a hypothetical where instead of after she files the formal EEO complaint, he says, I can't do anything more. I'm not going to do anything more with your transfer request now because I'm going to leave it in the EEO's hands. Instead of doing that, if he went to her before she filed the formal EEO complaint, he says, I understand you're thinking about filing a formal EEO complaint. Here's the deal. You could do that, but if you do that, I'm going to withdraw from helping you with this transfer. And would you say that she should look at that and think, well, that's not going to affect my decision about whether to file the formal EEO complaint. It's not going to dissuade me at all. I'm just going to do what I'm going to do anyways, as if he never said that.
I think a reasonable jury, a reasonable employee would not be dissuaded. They would say, okay, well, the resolution to my discrimination claim is not occurring now. Therefore, I need to continue with my discrimination complaint. So no, I don't think under even that hypothetical, which is not the facts of this case, that it would be a reasonable employee would be dissuaded. But there's one other point that I think is important, and I want to correct the record, and that is that when Mr. Finnegan made his decision to defer to and hand off to the EEO process, the person that Ms. Ramos was complaining about was no longer her supervisor. And I'll direct you to JA 601 and 602, where Mr. Finnegan is making reference to Ken James, who was her new supervisor. And so, and this is one of the things that makes this different from the Ortiz-Diaz case that was relied upon by Appellant in the briefing, and that is Ms. Ramos is not being left with the person that she feels is discriminating against her. She has a new supervisor. And so at the time that Mr. Finnegan makes the decision that, hey, we now have a mediation process, which all evidence suggests that he was going to participate in because he's giving the mediator his schedule for availability, is that she had a new supervisor who was happy to have her. Again, those two JA sites support that. She would be, continuing on with her EEO process. And otherwise, as the district court found, she was not materially harmed because that's what the court uses. Like, okay, is there a material injury here? And that's how we decide, is this going to dissuade a reasonable employee from engaging in the EEO process?
I'm sorry, so you're saying that she files her complaint against this particular supervisor.
Correct.
And by the time the transfer is withdrawn, the supervisor has changed?
That's correct, Your Honor. That's correct.
And so what happens to the EEO complaint once the supervisor isn't her supervisor? It doesn't become mooted or anything?
No. And but again, her claim continues. I mean, this is in some sense, this is the process. The EEO process is set up so that there is an informal complaint. There's a period of time in which the employer and the employee can figure out, okay, do I really want to continue with this? Is there an informal resolution? Mr. Finnegan participates in that. And then, by the time he gets an answer, it took 9 days for his offer, which again, he didn't think was, ultimately accepted because, there's evidence in the record that she wanted a temporary detail. He couldn't do that. And so, but the evidence in the record is that, by the time September 9 rolls around, there's just a new process. And that's just how the process works.
For purposes
formal.
So for purposes of material adversity, you're saying that it doesn't have the element from Ortiz-Diaz that she would have an opportunity to get away from the discriminatory supervisor. But there's also evidence that she, I guess a little bit later on, she's now become a known quantity, somebody who's a complainer. Does that affect the analysis on material adversity? She can get out of the job where she has a reputation and have sort of a fresh start and better opportunities.
Well, I guess I think Appellant has to pick what argument she wants. With the known quantity thing, that's a known entity. That was a remark in November of 2011 with respect to her grieving elements of a performance review. But that doesn't that doesn't make what happened in September material. And so,
But it's stating something that might have happened earlier, like that the statements made it in November, but she might have become a known entity time before that.
there's a lot of speculation
She
here.
was a known entity at that time. You know when it ripened. to be a known
Exactly. That's what I'm
entity.
trying to
Right, but I
Thank you.
think ultimately, if I were to encapsulate the entire case here, is that there's just a lot of failures of evidentiary proof. We see that in the transfer where there's no evidence that the decision makers were aware. There's no argument or evidence of pretext for the explanations for these various decisions. The district court got it correct. And I understand that I've run over. And so if there's any other questions, I'm happy to take it from your honors.
Could you address the denial of the motion for leave to amend?
Oh, yes,
Because
certainly.
I understand that the timing was that the motion for leave to amend was filed July 31st of 2015. I'm sorry, the motion was filed August 25th of 2015, but the performance evaluation claim exhaustion happened on July 31st of 2015. So that seems timely.
Right. The issue here with a couple of things. On the amendment, as one of your honors noted, plaintiff hasn't articulated a basis that Judge Jackson's decision not to amend on certain issues was an abuse of discretion. And with respect to the grieving, the performance evaluation, that was an allegation that was made in the context of other allegations about how the FBI allegedly handled her leave in 2013 and her return from leave. And so there were a variety of allegations that Judge Jackson said, okay, here's a bunch of stuff that's new. It's not related to the original case. And
So the allegation was not that performance evaluation was in retaliation for the same protected activity. It's different protected activity. Is that what you're saying?
no, what I'm saying is that appellant hasn't demonstrated that there's an abuse of discretion in keeping out the allegation of the performance appraisal in 2013.
But I believe the district court said a number of things. Some things were futile. Some
Right.
things she said arise out of different facts.
Right.
I'm just trying to hone in on
And,
what
and
you're saying happened, because I don't know that it arise out of different facts, because come to find out on summary judgment, you're relying on those very same performance evaluations to say that there was no retaliation and not giving
No.
you the transfer. So it seems to be part of the same nucleus of facts. And then the question is just, you're supposed to allow amendment. It's supposed to be freely given unless you actually have a reason not to. And it seems that discovery was open. These claims had just been exhausted. Why is it not an abuse of discretion to deny that if it is part of the same nucleus of facts? There is no
it wasn't.
undue delay on their part. They did it as soon as that was exhausted.
It was not presented as part of the same nucleus of facts. It was presented in proposed paragraph 18C, and that allegation about her minimally successful rating was alleged in the context of events that occurred while she was on leave for surgery in December of 13. And all of those allegations about what happened during her leave and after her leave was determined by Judge Jackson in the exercise of her discretion as being not sufficiently related to the original.
So it is true, as my recollection is, it is true that the way they were teed up seemed to tie the allegations about the 2013 performance review to the ones about the firearms. And so
Correct.
It seemed like it was a different factual complex. I think my recollection is that is
Yes.
right in the way it was teed up. But in the way that the 2013 performance evaluation actually factored into the denial of summary judgment, it turns out it's not factually distinct, because that is the basis for saying that there was a denial of a transfer to Boston and New York.
But there's essentially if it came into the case, that is, if the 2013 performance appraisal had come into the case as its own claim, then the evidence of it factoring into a transfer later on would be evidence of the materiality of that, retaliatory, allegedly, performance appraisal. it would not make a subsequent decision by a different entity using different criteria retaliatory.
I think it could. It definitely could, because if there's retaliation that ultimately is manifested in a denial of transfer, that kind of thing happens. That we have discrimination claims where even if the ultimate decision maker is making a decision based on something that they think has sanctity, that if it's infected in the process going up, that ultimate decision is still invalid. And that's what would be the basis here. Is you'd say the 2013 performance review was a product of retaliation, and then that became the basis for the denial of transfers to Boston and New York.
Respectfully, I'm not aware of akin to a fruit of the poisonous tree situation.
Isn't that the cat's paw theory? Isn't that basically how that works? No.
But you actually have to, in the cat's paw theory, you would be infecting the original retaliatory person with the retaliatory animus, would then be infecting the decision by the, for the later decision. And that's kind of what we have here is that later on you have a transfer unit making a decision based on its neutral criteria that, hey, in the most recent review session, you need to have at least a minimal performance appraisal. And so that wasn't there. And so the transfer decision.
It's still the but-for
So
cause.
let's suppose that the undisputed evidence based on videotapes were that we're going to give her a bad performance review so that she'll never, ever be able to transfer in the future because we don't like her because she's filed EEO complaints. And then it's also undisputed that later the FBI transfer unit, they know nothing about her EEO activity. Their motives are completely pure. And they just say, well, based on the criteria, we can't consider you for or approve you for a transfer because you don't have, satisfactory performance appraisals. So you're saying in that world, summary judgment gets granted for the government, and it doesn't matter that there was essentially, discriminatory action to prevent her from ever being transferred in the future.
I believe that's correct because, we also have to assume that, there's materiality present, right?
Let's assume that.
And so if we're just focusing on causation, there's still no evidence that the decision, the later transfer decision under challenge was because of her protected activity. If that decision, as it was based on a neutral policy. There isn't, perhaps the facts, if there was some connection, some actual factual connection between the two events that taints the later event. But here, it's a separate allegation, it's a separate discrete event. And the question before the court is, did the district court make the right decision? And the district court make the right
So your argument is that she would have a claim to, assuming she exhausted, et cetera, to challenge the negative performance evaluations as a claim.
Correct.
But that is essentially irrelevant, or at least not enough to defeat summary judgment when those discriminatory performance evaluations were used in a later transfer.
I would agree with that.
And so you're saying the district court didn't abuse its discretion in denying the motion to amend to add this. So is it your position that she should just bring a whole new case alleging the retaliation based on the performance evaluations? Why is that better than just putting it into this case?
Well, again, it's not a question of is it better or not? The question is, did Judge Jackson abuse her discretion? And she didn't, because she interpreted the complaint, and based on as the chief said, this allegation was made in the context of other events, and she said, okay, I got nearly 24 additional allegations of retaliation. What do I do with it? And so she made a very, I think, thoughtful analysis using the Rule 15 standards and said, okay, these ones are just too distinct from the original allegations, and it would cause delay, additional discovery. In terms of the timing, which I know is one of the questions, this amendment occurred 6 weeks before the scheduled close of discovery. And, and so that was factoring into Judge Jackson's analysis that, hey, listen, this is, we're basically at the finish line, and now we want to, appellant wants to, or Ramos wants to start with new allegations.
The finish line often moves in district court.
Right, but
6 weeks before the close.
But that's why,
not that close.
but that's why the judge has discretion to figure out how to manage her docket. And, in this case, Judge Jackson, and it hasn't been, articulated in before Your Honor by appellant that this was an abuse of discretion.
Sure, my colleagues don't have additional questions for you, Ken. Thank you.
Thank you. Thank you, Your Honor.
Mr. Cooper, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor, and I'll try to be quick. I appreciate the time. I guess the first observation I want to make is a general one, and it's how much these arguments that you're hearing today depend on the facts of this case, the evidence, the competing evidence in this case. And I think that goes to our broader point that summary judgment should not have been entered against Ms. Ramos. Just to address a few of the specific points counsel for the government raised. One, he said that there's no evidence that what Jet did when removing Ms. Ramos, there's no evidence that their explanation for removing Ms. Ramos from her position, her supervisory position, was pretextual. They ignore the second time that they removed Ms. Ramos from this position. They offer, and the district court made the same mistake. They focus on the temporary removal of her from this position in favor of another employee who then stepped down unexpectedly 2 months later. They put Ms. Ramos back there, but they got rid of her a second time. They never offer an explanation for that. They don't say it's because they were, busy because she was on leave, because she wasn't on leave. So they haven't offered any non-pretextual reason as to why she was removed that second time. The second point I want to address concerns the 2011 transfer. I neglected to mention earlier, but Mr. Finnegan understood at the time he said he would defer to the EEO, or effectively the time that he removed the offer to transfer Ms. Ramos. He understood at that time that he could have consummated the transfer and allowed her to go to that new position. He chose not to do that. We think the court's correct, and it's at least it's questioning that suggests that's retaliatory. We think clearly it meets the standard set forth in Burlington North v. White, because, again, any reasonable employee would be dissuaded from filing a formal complaint if they knew, if I file this formal complaint, that transfer offer I want, that's been offered to me, if I file this formal complaint, I'm going to lose it. That's exactly the kind of thing that would dissuade a reasonable employee from engaging in protected activity. Just to paraphrase an observation this court made in the Chambers case, refusing to transfer one employee but transferring a second employee, it treats the first employee worse than the second employee. We think there's a certain common sense element here that refusing to transfer someone after you told them you transfer them because they filed a formal EEO complaint does not only have retaliatory intent, but it's adverse because it deters protected activity. The other point I'll make on the argument that the government makes about deferring to the EEO process is this isn't a defense that they raised in their answer that we didn't retaliate because we were deferring to an agency. It's not an argument that they raised in their briefs below, at least not a legal argument they raised. Instead, it's one they came up with on appeal for the most part that says, what they were really doing was handing it off to the EEO. Ultimately, it doesn't matter what their explanation is after the fact. When you take away a transfer offer from someone that you don't have to take away, that's adverse action. But I did want to at least note that unless the court...
On the motion to amend, don't we have to, we can't Monday morning quarterback, so to speak, the district court. So if the motion to amend articulated like the argument for why these things were related and why the amendment should be granted, and didn't really connect up the performance evaluations to these, transfer requests in 2014, 2015, or I guess they were all in 2014. Can't blame the district court for that. We can't say that that's an abuse of discretion, that the district court couldn't look in their crystal ball and know that they were going to be related. That was plaintiff's job to explain the connection, right?
That is fair. And Your Honor's question reminds me that I didn't answer Your Honor's question about discovery. It was still open as of the time we moved to amend in 2015 to add this. And I think that's an important point when we consider whether or not the judge abused her discretion. Discovery was still open. We didn't know exactly how the government might attempt to explain away the 2013 and 2014 retaliatory actions. And as it's played out, we see now that the performance.
But was discovery likely to be able to be concluded on these new claims within 6 weeks?
I think that would have been a challenge if I'm answering.
Yeah, exactly.
Your Honor,
So discovery was still open, but granting this motion was going to require extending the discovery deadline, right?
Correct. It would have required extending the discovery deadline. My point is that we weren't at a point in the litigation where we could explain the connection between the performance evaluation and the refusal to transfer to Boston and New York, because we didn't know the government would be relying on that the way that they ultimately did.
Why wouldn't you know that? Why hadn't you taken discovery on those transfers, the New York and Boston transfer requests?
I believe, yes, we had taken discovery on that. And again, I'm not sure what our particular arguments were when moving to amend. And I don't have that proposed amended complaint in front of me. Unfortunately, I do know that it was at least according to the government, it was a subparagraph that we raised those allegations in, which suggests to me that it was part of a sort of broader allegation. But again, I apologize that I don't have that information readily available to answer your question.
All right, thank you.
Thank you, counsel. Thank you to both counsel. We'll
Thank you,
take this
Honors.
case under submission.